Okay, let's see. Okay, before I begin the trial, I want to make sure we have, I go over the pretrial procedures. Again, I'm Judge McLeod. I want to ask if both sides are ready for the trial.
The people are ready.
Yes, Your Honor.
Okay, I didn't hear Mr. Colby.
Apologies, Your Honor. The people are ready for the proceedings.
Okay, is there any way that you can turn up your mic or get closer?
Yes, Your Honor. Is this better?
Yes, it is. Thank you. Okay. I have the trial roster. So let's see. I want to confirm that if there's any video recorders present or being used, that both teams have approved the taping. Otherwise, there needs to be no video recording or any audio or video recording. Let me read this. Inform teams as well, let's see, as gallery members that the Colorado Bar Association may be taking photographs of the competition during the round, and that the team participation in the tournament, the state tournament grants automatic permission, and the use of these photos by the Colorado Bar Association. If there's anybody in the gallery who is connected to the teams not competing in this round, they must leave the courtroom. If there's anybody in your the participants' room at your location, they need to also leave. Just to remind the teams and the coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. Also remind the team that the compliance with the time requirements will be considered in scoring individual performances. This time I'm going to ask each team member to introduce themselves. And I'll let Mr. Is it Lish?
Yes, Your Honor.
Okay, you're for the prosecution?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Colby Lish, and today, along with my co-counsel, I will represent the people of the state of Colorado in the matters of the state versus Avery Becker. Today, I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Mr. Taylor Perkins. May my co-counsel introduce themselves.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Zarina Yufa, and today I will be conducting the direct examination of Mr. Alexi Fuentes, the cross-examination of Miss Avery Becker, as well as delivering the closing arguments.
I can't hear you, Ms. Davis.
My apologies, Your Honor. Good afternoon. And good afternoon, members of the jury and opposing counsel. My name is Jordan Davidson, and today I will be examining Ms. Kyle Kuzak on direct, cross-examining Professor Van Owen, as well as giving the opening statement for the prosecution. May our witnesses introduce themselves?
Yes, please.
Good afternoon, Your Honor. Ladies and gentlemen of the jury, opposing counsel. My name is Louis Sharp, and I am Alex Fuentes.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Connell Barton, and I am Jordan Markowitz.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Morgan Romine, and today I am Kyle Kuzak.
Okay, next we're going to have the defense introduce themselves.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Moraine, and I will be conducting the direct examination of Professor Blake Van Owen and the cross-examination of Jordan Markowitz. May my co-counsels introduce themselves?
Yes.
Good afternoon, Your Honor. My name is Adele Donda, and I will be conducting the direct examination of Taylor Perkins, the cross-examination of Alex Fuentes, and the opening statement.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Audrey Davies, and I'll be conducting the direct examination of Avery Becker, the cross-examination of Kyle Kuzak, as well as the closing argument.
May our witnesses please introduce themselves?
Yes, go ahead.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Taylor Davis, but today I am Professor Blake Van Owen.
Hello, Your Honor, opposing counsel, and members of the jury. My name is Tommy McKissick, and I will be playing Taylor Perkins.
Good afternoon, Your Honor. My name is Millie Bjork, but today I am Avery Becker.
Okay, I think we're all on the same page. Because this is Zoom, we're going to stay seated. However, if you do want to stand, that's fine with me. Just make sure we can see your face. Let's see. I'm going to swear in the participants and the witnesses, the team members, the witnesses, and the gallery members. First, I'm going to do the team members. Please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor.
Okay. For the record, I'll note that everybody said yes or either nodded their head. Yes. Do we have any gallery members?
No, Your Honor.
Okay. Scoring panelists, please raise your right hands. Do you swear to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Your Honor.
Thank you. Okay. Let me call the case of the people of the state of Colorado versus Avery Becker. Does the prosecution, actually, let's do preliminary matters. In terms of the closing statement, does the prosecution want to address that?
Yes, Your Honor. The prosecution has a few preliminary matters. First of all, we would ask that all remaining time in the closing statement be reserved for a rebuttal.
Anything else preliminarily that you'd like to address?
Yes, Your Honor. The prosecution would ask that all charges and stipulations be constructively published to the jury before the trial begins.
Okay.
The prosecution would also like to ask that all admitted evidence also be constructively published to the jury upon its admittance.
Ms. Moraine, is it Moraine? Moraine?
Moraine, Your Honor.
Moraine, sorry. Do you have anything to state for preliminary matters?
Yes, Your Honor. We would ask that if there are any technical difficulties, that time be paused for both teams.
Anything else?
Does Your Honor and members of the jury have copies of our team's trial roster?
I have copies. It was in the chat. The courtroom monitor placed it in the chat. Do the jurors have copies of the roster?
Yes, we do.
Anything else we need to take up before we proceed with opening statements?
Your Honor, if we do experience technical difficulties and need to pause time, I ask that you verbally speak when to pause and when to unpause. This will avoid any time discrepancies between the two teams.
I'll do that. Thank you. Anything else before we proceed?
The prosecution is ready to proceed.
Okay. Go ahead, Mr. Lish, with your opening statement.
Your Honor, Ms. Davidson will be delivering our opening statement for you.
Okay.
May I proceed, Your Honor?
Yes, please.
On March 6th, 2020, a masked intruder breaks into a house on Flower Street. Just minutes later, the same masked intruder flees, leaving carnage in their wake. A dead body lies on the floor of the patio, a gaping wound in its shoulder, while next to it, a knife drips blood. This is the corpse of Mackenzie Brackman. And today, the prosecution will prove to you, beyond a reasonable doubt, that that masked intruder was the defendant, Avery Becker. Not only will we show you that Becker had the motive, means, and intent to commit this crime, we will show you how resentment seethed to anger, and anger exploded to fury. Today, the defendant has been charged with 2 crimes: felony murder and second-degree burglary. Simply, the prosecution must prove that Avery Becker broke into Mackenzie Brackman's house, and while Avery Becker was in that house, Mackenzie Brackman died. Furthermore, we will show you that Avery Becker intended to at least vandalize the property. But let's start at the beginning. Mackenzie Brackman was a celebrated criminal defense attorney and a man kind enough to donate his time to coaching a high school mock trial team, a team that the defendant belonged to, at least until their expulsion. You see, Mackenzie Brackman had clear and reasonable expectations. The defendant didn't think those rules applied to them. Resentment seethed. You'll hear about this resentment from prosecution witness Alex Fuentes, but you'll also hear about it from defense witness Taylor Perkins, who happens to be the defendant's best friend. You'll hear about it from the defendant themselves. Now this resentment seethed to anger when Brackman demoted Avery from A team to B team. Rather than repent, the defendant manipulated Taylor Perkins into dropping mock trial. Throughout this case, you'll see how Avery asks and Perkins follows. Puppetry at its finest. And once Avery was back on A team, were they satisfied? No. Coach Brackman asked them to work just a little bit harder. The defendant grabbed a permanent marker, stormed outside, and vandalized Mackenzie Brackman's car. Brackman kicked Avery off the team for good. And resentment seethed to anger, and anger exploded to fury. The defendant texted Alex Fuentes a plan. They said, I'm going to wait until he's not at home, then break into his house and trash it. And that'll show him. That'll show him. The defendant wanted to teach Brackman a lesson. It turned out to be a deadly one. So on March 6th, 2020, the defendant breaks into Mackenzie Brackman's house, stabs Brackman, leaves, and rides in the car with Taylor Perkins, who calls 911. Now, this would be all that the prosecution has to prove to you to show that Avery Becker is guilty. But we're going to give you more. We're going to give you crime scene reconstruction expert Kyle Kuzak, who's going to walk you through how Brackman brought the knife into the situation. We're going to show you Detective Jordan Markowitz, who will show you how the defendant's phone was at the scene of the crime when the crime was taking place. And we're going to show you that it was Avery who brought the knife down through muscle, bone, aorta, because of his resentment that seethed to anger and exploded to fury. When we ask you to find the defendant guilty, you will know the right answer. Thank you. Your Honor, I believe you're muted.
Sorry, we had some sirens that went by. Defense, do you have an opening statement?
Yes, Your Honor. May I begin?
Do you have your video on?
Yes.
Okay, go ahead.
Alex Fuentes had a dream and a plan. Alex spent hours preparing for mock trial, perfecting crosses and directs, and rereading and analyzing the case year after year. But Alex was still no match to Avery Becker. Avery was quick on her feet, intelligent, and a natural mock trial star. The only way Alex could stop Avery Becker would be to lock her behind bars. Members of the jury, this is a case about jealousy, a case about rivalry, and a case about a school dispute between Avery Becker and Alex Fuentes taken too far. Alex Fuentes convinced Alex's friend Blair Rollins to work together to murder Mackenzie Brackman in cold blood and frame Avery Becker for their malicious crime. Alex wanted to get Avery out of the way so that Alex could be a mock trial star, while Blair Rollins wanted to avenge Blair's father's incarceration. The burden in this case is on the prosecution. The prosecution must prove beyond a reasonable doubt that Avery Becker committed first-degree murder or second-degree burglary. As you listen to the evidence presented today, ask yourself 3 questions. First, how reliable was the murder investigation in this case? Second, where was Avery Becker on the day of Mackenzie Brackman's murder? And third, are there other suspects who might have had a motive and plan to kill Coach Brackman? To answer these questions, the defense will provide 3 witnesses: Blake Van Owen, Taylor Perkins, and Avery Becker. You will first hear from Blake Van Owen, a private investigator who reviewed the police investigation. She will explain that the prosecution's homicide detective, Jordan Markowitz, conducted a rushed investigation and never even considered other possible suspects in this case. Ms. Van Owen will explain the many deficiencies in the detective's investigation, the conclusions about the murder weapon, and the conclusions about cell tower data and Avery Becker's phone. You will next hear from Taylor Perkins, the defendant's best friend. Mr. Perkins will testify that he was with Avery all day on the day of Coach Brackman's murder. He will testify that he and Avery were looking for Avery's lost phone and that they were nowhere near Mackenzie Brackman's house. Mr. Perkins will further testify that the last time he saw Avery's phone was when he and Avery were with Alex Fuentes at the Fry Shack. And finally, Mr. Perkins will explain how jealous Alex was of Avery Becker's natural mock trial abilities. Finally, you will hear from Avery Becker, the defendant. Ms. Becker will testify that Alex was jealous of her mock trial abilities and that she and Alex were never even friends. She will further testify that she was with Taylor Perkins on the day of the murder looking for her lost phone. She will tell you that she never could have sent certain text messages from her phone because she didn't have it with her. And finally, she will explain her belief that Alex Fuentes took her phone so that Alex and Blair could set it up to look like Avery had gone to damage Coach Brackman's house. After you hear from these witnesses, the evidence presented will demonstrate that the prosecution has failed to show beyond a reasonable doubt that Avery Becker committed this crime. The evidence presented will demonstrate that there is no physical evidence to connect Avery Becker to the scene of the crime. In fact, the testimony will show that Avery Becker was not at the scene of the crime, but rather with Taylor Perkins looking for Avery's lost phone. And finally, the evidence will demonstrate that Alex Fuentes worked with Blair Rollins to frame Avery so that Alex could fulfill Alex's mock trial dreams. Alex Fuentes had a dream and a plan. A dream to be a mock trial star and a plan to commit.
Excuse me, time.
Thank you, Your Honor.
Thank you, counsel. Prosecution, would you like to call your first witness?
Yes, Your Honor. The prosecution calls Alex Fuentes to the stand. Permission to proceed?
Yes, please do.
Can you please introduce yourself to the jury?
Sure. My name is Alex Fuentes, but that really shouldn't be necessary. I'm kind of a big deal in the mock trial community, so everybody probably already knows who I am.
Mr. Fuentes, where do you participate in mock trial?
Well, that'd be Colorado High School, but most people call it CHS.
Colorado High School. Do you know Mackenzie Brackman?
Yeah, I knew Mr. Brackman. He was my coach for 3 years.
How close would you say that you were with Mr. Brackman?
Well, I would say that Mr. Brackman and I were really close. You know, Mr. Brackman was something of a mentor, of a father figure to me. He was an extremely talented litigator, and it meant the world that he took his time to dedicate to mock trial, something that I was very passionate about.
Were you close with anyone else on the team?
Oh yeah, in order to be a member of mock trial, you have to get along with everybody. You know, you have to be a cohesive unit. So I knew everybody really well. I especially knew Avery.
Avery, you knew her very well. Did you happen to be jealous of Avery Becker?
No, Avery did well in mock trial. I'll give her that. But frankly, I think hard work is what's more important. And that's what I put in. You know, it just wasn't something to be jealous about.
Did you feel a pressure to be better than Avery?
No, in all honesty, I didn't. Avery and I were extremely close. That's why it's really difficult to be here today.
So you talk about being close with everyone on the team. Were you able to see through that any of Avery's relationship with Mr. Brackman?
Oh yes, absolutely. Their relationship was on full display for the rest of the team.
And what did you notice about that relationship?
Objection, speculation.
Response, Your Honor?
Yes, please.
Your Honor, the witness has testified that he was able to see a lot about what was going on in mock trial because he was close with everyone on mock trial. This is not speculation because I simply asked the witness what he noticed about a relationship that he already testified was on display for the rest of the team. This is not testimony about the mental state of either Mr. Brackman or Avery Becker.
Ms. Dondi, do you have a response?
Yes, Your Honor, this is speculation as Mr. Fuentes cannot accurately testify to a relationship between Avery Becker and Mr. Brackman.
Response, Your Honor?
Go ahead.
Oh,
No, go ahead, Ms. Yusuf.
yes, Your Honor. Your Honor, I did not ask Mr. Fuentes exactly what the contents of Avery Becker's relationship with Mr. Brackman looked like. Instead, I just asked him what he noticed about the relationship, not necessarily making an assertion about the reality of the relationship itself.
Okay, I'm going to sustain the objection. Proceed.
Now, Mr. Fuentes, were you able to hear any of Avery Becker and Mr. Brackman's conversations?
Yes, absolutely. And you know, the main gist of it was Avery just didn't show up prepared that often. You know, he would try to make things up on the spot, and I would put a lot of work into mock trial. So that was really, it was hurtful to the rest of the team that he was completely unprepared, and it really bothered, well, it bothered everybody.
Did Mr. Brackman do anything about Avery's unpreparedness?
Oh yeah. Yeah, at first he just tried to discipline him, you know, asked him nicely, politely to do more work. That wasn't enough. Avery actually showed up late to practice one more time, and he was demoted down to B team.
Wow. Did Avery Becker ever go back onto A team?
Oh yeah, he found his way back on. You know, he got one of his close friends, Taylor Perkins, to move down to B team with him. They knew that if there was a spot on A team that needed to be filled, they would need somebody who knew the case extremely well. That was Avery Becker. So Avery found her way back onto the team.
Did Avery's relationship with her coach change after that, from what you could see?
Based off of my perception, things only got worse from there. You know, Avery still didn't put in the necessary work. Things actually came to a head right at the regional competition.
And what do you mean by that?
Well, Avery scored very well at the regional competition. I'll give her that. You know, she won all these awards, all sorts of great stuff. But she was completely unprepared. She improvised everything. It was that kind of thing that really bothered Brackman, and he let her know at the end of the competition.
What do you mean by he let her know?
Well, in our mock trial room, we have this big whiteboard, and right next to it, there's this easel with a paper on it. And after the big competitions, we always write down feedback about what we could have done better. You know, for me, it was a whole lot of attaboys, did great. But for Avery, he said that in real life, what he did would be malpractice.
Objection, hearsay.
Response, Your Honor?
Go ahead.
Your Honor, this is not hearsay because I am using it for the purposes of the effect on the listener. I am not using it to prove whether or not Avery's actions would have been malpractice in real life. Instead, I'm using it for the effect that it had on Avery.
I'm going to sustain an objection. Continue, counsel.
Yes, Your Honor. So what happened with Avery after this feedback? Oh, after this feedback session, my apologies.
Yeah, no worries. Like I was saying, Brackman was just really, really upset. You know, they didn't put in the necessary work.
Objection, speculation.
Response, Your Honor.
Yes, please.
Your Honor, Alex Fuentes was at this practice after regionals, and he was proxy to seeing this interaction between Mr. Brackman and Miss Avery Becker. Therefore, it is not speculation to say that Mr. Brackman was outwardly upset, because upset can be seen, or at least some symptoms of upset can be seen from an outward appearance.
Ms. Donde, response?
Mr. Cifuentes cannot accurately testify to the emotional state of Mr. Brackman, as he does not have personal knowledge under Rule 602.
Objection overruled. Proceed, Ms. Yufa.
Mr. Cifuentes, what were you saying?
Well, I was just saying that Mr. Brackman was really upset. And he said some stuff that really seemed to bother Avery. So Avery ran over to that easel, the one that I mentioned earlier, picked up a marker and ran outside.
Then what did Avery do?
Well, Mr. Brackman used to drive this beautiful Porsche. That's how you know you got a good lawyer, when they drive a nice car like that. And all right on the hood, in big, bold letters, Avery wrote, "Worst Attorney Award."
Objection, unfair prejudice.
Ms. Yufa?
Your Honor, may opposing counsel please elaborate on their objection?
Ms. Donde, please elaborate.
Under Rule 403, this testimony is unfairly prejudicial and it outweighs the probative value.
Response, Your Honor.
Yes, please.
Your Honor, it is not. Your Honor, this evidence is not more prejudicial than probative, because this is a case about someone with the motive to destroy Mr. Brackman's private property. Your Honor, this is evidence prior to March 6th about someone with the motive and someone who completely did destroy Mr. Brackman's property. Therefore, it is not more prejudicial than probative because it goes to the identity of the perpetrator of the crime on March 6th, as well as it goes to Avery Becker's feelings towards Mr. Brackman and Avery Becker's hatred of Mr. Brackman.
Objection overruled. You may, Mr. Sharp, you may continue, or Ms. Yufa, you can redirect him.
Mr. Cifuentes, what were you saying?
Like I was saying, right on the hood of Brackman's beautiful Porsche. Worst Attorney Award. I mean, you just can't come back from that.
What did Mr. Brackman do about that?
Well, Avery was off the team for good. Like I was saying, there's just nothing he can do after that. I mean, that doesn't mean that Avery didn't try. Sure, he tried to text me. Apologies are one of my strong suits, but I couldn't do anything.
Let the record reflect that I'm asking the timekeeper to screen share a copy of what has been previously marked as Exhibit 14. Mr. Cifuentes, do you recognize this?
Yes, ma'am. These are the text messages that I received from Miss Avery Becker.
And do you currently have the phone with these text messages on them?
No, I do not. It did not hold a very good charge at all. It's kind of the point of having a phone, so I got rid of it.
Are you aware that this is a screenshot of those text messages then?
Yes, ma'am. If I remember anything from mock trial, it's this whole exhibit authentication business. I promise you this is a fair and accurate copy of what I received.
Thank you, Mr. Cifuentes. Are you the one who did take these screenshots?
Yes, ma'am.
The prosecution moves Exhibit 14 into evidence.
Defense, do you have any objection?
Yes, Your Honor, but first I would like to request permission to voir dire the witness.
On what grounds?
On the grounds of will object to authenticity under Rule 901, best evidence under Rule 1002, and hearsay under Rule 801.
Okay, proceed with the voir dire.
Response, Your Honor.
Go ahead.
Pursuant to the mock trial rules of evidence or the mock trial rules of procedure, an opposing counsel is not permitted to voir dire an exhibit. Therefore, I would ask that opposing counsel not be allowed to voir dire on this exhibit.
Defense, do you have a response?
No response, Your Honor.
Okay, I'm going to deny the request to voir dire. Ms. Yufa, please proceed.
And just to clarify,
sorry, I'll admit into evidence exhibit 14.
yes, Your Honor. Mr. Fuentes, is this what you were talking about when you said that Avery asked you to apologize?
Yes. You know, he knew that I was close with Coach Brackman, or she rather knew that I was close with Coach Brackman. And well, she wanted to apologize to Brackman, but like I said, I couldn't do anything to help her out.
What happened after she asked you to apologize to Mr. Brackman?
Well, then that's when things got really disturbing.
I'm sorry, but what do you mean by that?
Well, he said something to the effect of, if you think he was upset when he saw what I did to his car, wait till you see what I do to his house.
Did Mrs. Becker say anything else?
Yeah. Yeah, she actually elaborated on her plan. She said, I'm going to wait until he's at work and then break in and trash it.
Timekeeper, can you please stop screen sharing Exhibit 14? I know this must be hard for you, Mr. Cifuentes, but are you sure that it was Avery Becker who sent those texts?
There's no doubt in my mind that it was Avery Becker who contacted me that day.
And when did this happen?
I received these texts mere hours before Mr. Brackman was found dead.
Thank you, Your Honor. I have no further questions.
Thank you. Defense, do you have a cross of the witness?
Yes, Your Honor. May I begin?
Yes, please.
Good evening, Mr. Cifuentes. My name is Adele Donda, and I would like to ask you a few questions.
Good evening, Ms. Donda. No problem.
You testified that you and Avery were on the mock trial team together at Colorado High School, correct?
Yes, that's right.
Avery was pretty good at mock trial, wasn't she?
Yes, absolutely.
And you were pretty good too, weren't you?
Oh yeah, you bet.
But no matter how hard you tried, Avery was always better than you, wasn't she?
Well, Avery always scored better. I think there's a fine distinction there, considering mock trial is an extremely subjective competition.
So that's a yes.
Not quite.
And it was frustrating for you that Avery would do so well without trying, wasn't it?
Yes, absolutely. I think it bothers the rest of the team as well.
So you'd admit you were a little jealous of Avery.
I just would not go that far.
Oh, but you were so jealous of Avery that you even thought Coach Brackman should have pressed criminal charges against her.
That had nothing to do with jealousy. All I mean is that I would have pressed criminal charges myself if my car was destroyed.
Now, moving on, please direct your attention to previously admitted Exhibit 14. Exhibit 14 is a screenshot you said you took of text messages on your phone, correct?
Yes, ma'am.
When you met with the detective, though, you didn't bring your phone, did you?
No, I did not, and I admit that's a big mistake. It's one of the things that I feel worst about in this trial, but Detective Markowitz assured me that the best thing to do was to send screenshots.
So instead, you sent screenshots of your phone to the detective, correct?
Yes, ma'am. That's what Detective Markowitz indicated that I should do.
So you're the only one who saw those text messages in Exhibit 14 on your actual phone, correct?
I'm not sure, frankly, but I definitely know that I received them.
And you testified that you don't have your phone anymore, didn't you?
That is correct, yes.
So you couldn't even show me the text on your phone right now because you conveniently got rid of the phone, correct?
Again, I didn't conveniently get rid of the phone. It didn't hold a very good charge, so that's why I got rid of it. But technically, you are correct. I could not show you the text on my phone.
So we really can't confirm that Exhibit 14 was an actual screenshot then, can we?
Yes, you can.
Okay, so let's assume for a minute that these really are actual screenshots from your phone.
Okay.
Could you look at the top of the screenshot and tell me, is there a time on that screenshot?
It would be helpful if the timekeeper could share the exhibit, but I do believe it says 15:06 if my memory serves correctly.
Yes, you are correct. And that's the time you took the screenshot right before you sent it to the detective, correct?
Yes, ma'am.
But there's no time indication on the individual text between you and Avery, is there?
No, there is not, but I could definitely tell you when I received them.
So we really don't know when those texts were sent, do we?
Well, yes, you do.
But is there a date indicating the day the texts were sent in Exhibit 14?
Oh, not in Exhibit 14, but I promise you I could definitely tell you when I received those text messages.
So these texts could have been sent before or after the murder of Mackenzie Brackman, correct?
No, ma'am.
I'm simply asking you to answer these questions based on your knowledge of Exhibit 14.
Very well.
So we do not know if you created these texts or if Avery sent them then, do we?
Yes, we do. I received them from Avery Becker.
Now, moving on, let's go back to the day you saw Avery and Taylor at the Fry Shack after Avery got kicked off the team. You and Avery had a good talk that day, didn't you?
Yes.
And Avery even let you play a game on her phone, didn't she?
Yes, that's correct.
So tell me again, you did have Avery's phone that day at the Fry Shack?
Momentarily while I was playing a game on Avery's phone, yes.
Thank you. I have no further questions.
Your Honor, I believe you're muted, but I do not have a redirect.
Sorry, you don't have a redirect?
No, I do not, Your Honor.
Okay. So, prosecution, are you ready to call your second witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Proceed.
Good evening. Will you please introduce yourself to the court?
Good evening. My name is Detective Jordan Markowitz. I've been a detective with the Denver Police Department for the last 7 years.
Detective, do you have any special training in your work?
Yes, I do. I specialize in homicides. However, I also have a certification from the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
Do you use this certification in day-to-day activities?
Yes, sir.
Have you testified using this data in court?
Yes, sir. I've testified in over 50 cases using this.
Thank you very much, Detective. The people now move to admit Detective Jordan Markowitz as an expert homicide detective and an expert in cell phone data recovery and analysis.
Defense, do you have a response?
Yes, Your Honor. May I please do a voir dire of the witness?
Yes, you may. As he is an expert witness, that's allowed.
Thank you. Detective Markowitz, does your work as a homicide detective include crime scene analysis or crime scene reconstruction?
No, it does not conclude crime scene reconstruction.
But it does include crime scene analysis.
I am familiar with it. However, I would not be considered an expert in it.
So, in fact, You've done a number of specialized trainings, though, in the area of cell phone data analysis, correct?
That is correct.
But you don't have any special certification in the specific area of crime scene reconstruction, do you?
No, I already iterated that.
You also don't have any specific training in the specific area of crime scene reconstruction.
No, ma'am.
So essentially, you haven't had any formal education or training in the area of crime scene reconstruction.
No, I believe I've stated that already.
You also don't have any formal certification or formal training in crime scene analysis, isn't that right?
No formal training on that front. However, I do a good manner of that in my daily job as a homicide detective.
So, for example, in this case, you have no specialized training in blood splatter analysis, do you?
No, I do not, ma'am, but I see quite a lot of that as a homicide detective.
Your Honor, based on the witnesses' responses and their admission that they do not have a degree or any formal education or training in the area of crime scene reconstruction or the area of crime scene analysis, I respectfully request that this expert witness be limited to giving expert testimony only in the area of cell phone analysis.
Response, Your Honor.
Let me just clarify something. So you're objecting to the reconstruction and the analysis. What about the cell phone?
I have no objection to Detective Markowitz being qualified as an expert in cell phone data analysis.
Okay. Mr. Lish, you may respond.
Your Honor, the prosecution is not admitting Detective Jordan Markowitz as an expert in crime scene construction and analysis and would therefore have no objection to crime scene reconstruction. However, as to crime scene analysis, I do believe that falls under Detective Markowitz's work as a homicide detective, and seeing as he has 9 years of experience, I would say that he is qualified under Rule 702 to testify to his analysis of the crime scenes which he investigates.
Your Honor, may I briefly respond?
Yes, briefly.
Detective Markowitz's experience as a homicide detective does not immediately translate to his expertise in the area of crime scene analysis, as becoming an expert in the area of crime scene analysis requires specific and formal training beyond that which is gained as a homicide detective.
May I briefly respond, Your Honor?
Yes, go ahead.
Pursuant to Rule 702, to qualify as an expert, a witness must have one of 5 things: skill, knowledge, experience, expertise, or training. While it is true that Detective Markowitz does not have specific training in crime scene analysis, he does have sufficient skill and expertise in the field to be qualified as an expert.
I'm going to allow Mr. Markowitz to testify as an expert in this case. In terms of the cell phone, there was no objection on the defense side, and he has training and expertise in that field. In terms of the analysis, he does have the background, the training as a homicide detective and an officer to testify in that area. So I'm going to find that he's an expert in terms of the analysis. Anything else we need to deal with before you proceed?
No.
No? Okay. Mr. Lish, you may continue your examination of Mr. Markowitz.
Thank you, Your Honor. Detective Markowitz, how are you first introduced to this case?
In this case in particular, I received a call from dispatch informing me of an incident on 444 South Flower Street. So I went to the scene.
What did you first notice on the scene?
Well, aside from the obviously marked off area, I noticed that there was a body just within the front door.
Now, did you identify that body?
Yes, that was Mackenzie Brackman.
And did you identify what killed him?
Yes, there appeared to be a large stab wound in his shoulder.
Now, Detective Markowitz, when you responded to the scene, did you have a forensics team with you?
Yes, I always do.
Did they photograph the scene?
They did.
And would you recognize a copy of one of those photographs?
Yes, sir.
Will the timekeeper please share Exhibit 1? Detective Markowitz, is this a fair and accurate representation of Mr. Brackman's body as the way you found it on March 6th?
Yes, sir.
The prosecution now moves to admit Exhibit 1 into evidence.
Defense, do you have any objection?
Yes, Your Honor. The prejudicial value of Exhibit 1 outweighs its probative value because while it is likely to prejudice the jury, it is unlikely to aid in their understanding of the case.
I'm going to overrule the objection. While there is, I understand your concern, counsel, but this is evidence that I believe the jury does need to see. So counsel for the prosecution, you may proceed.
Detective Markowitz, did you investigate the home?
Yes, I did. I did a further investigation of the home, and I concluded that no large electronics or valuables seemed to be out of place, which was peculiar, and ruled out the idea of a theft, which really narrowed it down to burglary.
Now, timekeeper, thank you very much for sharing Exhibit 1. You may now close the exhibit. Detective Markowitz, what was peculiar about the lack of the presence, rather, of expensive objects in the home?
Well, like I stated earlier, typically when you have a home intrusion and a murder, you'd expect the valuable things to be missing. However, this wasn't the case. And as a result, it was quite odd.
Now, what did that lead you to conclude about the burglary that took place?
Well, I was able to conclude that it didn't seem whoever broke in there was planning on stealing anything from the home.
Thank you very much, Detective. While you were analyzing the home, did you encounter any home security systems?
Yes, I did. I noticed several Ring doorbell systems installed on the home.
And could you briefly, for the jury, explain what is a Ring doorbell camera?
Absolutely. So a Ring doorbell camera is merely a high-tech doorbell with a motion-activated camera. So whenever someone walks in front of it, it will capture a video of that person and send it to the resident's owner.
And were you able to recover the videos that were sent to the resident's phone?
Yes, we were.
Did you download those videos into evidence?
Yes, I did.
And would you recognize a copy of one of those videos?
Yes, sir.
Would the timekeeper please share Exhibit 13? Detective, is this a fair and accurate representation of a video that you downloaded off of Mackenzie Brackman's cell phone?
Yes, sir.
The prosecution now moves to admit Exhibit 13 into evidence.
Defense, do you have any objection?
No objection, Your Honor.
Prosecution, you may proceed.
Detective, can you see a street in this video?
No, the only thing visible in this video, aside from the intruder fleeing, is the brick privacy wall on the back side and what I can only assume to be the back door of the neighbor.
Now, based on first of all, where was this camera?
I believe this camera was located at the front door of the residence.
So based on your analysis of the scene and consequent analysis of this video, do you believe that it would be possible to see Mackenzie Brackman's body from the street in front of the home?
Based on the location of the body, as well as the location of the street in respects to the door, I believe it'd be very hard to see someone lying inside the front door from the street based on their relative positions.
Thank you very much, Detective. When you downloaded the information off of Mackenzie Brackman's phone, did you search through his contacts to find any alternate suspects?
Yes, I did. And initially, I considered the fact that it could be a disgruntled ex-client. However, the amount of contacts relating to something called mock trial led me to follow a different path.
And what were your first few leads in mock trial?
Well, my first few leads in mock trial came from Alex Fuentes. However, my first few steps included downloading the contacts of every mock trial member.
Now, you mentioned Alex Fuentes. Were you able to arrange a formal interview with Alex Fuentes?
Yes, I was.
And what was the substance of that interview?
Alex Fuentes essentially gave me a brief rundown of the workings of the mock trial team. Especially with regards to Coach Brackman, notified me of some past incidences with another mock trial member and Mr. Brackman.
Now, who was that other mock trial member?
That member was Avery Becker.
And did you proceed to investigate Avery Becker?
I did. I attempted to arrange an interview. However, I was unsuccessful in that. And consequently, I settled for her CDR data records.
Now, did Alexi Fuentes give you any substantive evidence that led to your investigation of Avery Becker?
Yes. However, it was after the interview we had arranged. She mentioned that she had some text messages that were relevant to the case, and I asked her to send screenshots to me.
Did you find those text messages to be a reliable form of evidence?
Yes, they are. I use them all the time.
Now, Detective, you mentioned that you weren't able to arrange a formal interview with Avery. What type of data did you download from Avery Becker's phone?
That would be the CDRs.
And could you briefly, for the court, explain what are CDR data?
Absolutely. So CDR data is essentially any time your cell phone connects to a tower, whether that be a result of a text message or a phone call, it makes a record of that contact. And through that, I can track the specific cell tower that your phone is connecting to. And by analyzing the time periods in which you connect to a variety of different cell towers, I can essentially track a cell phone as it moves throughout the day.
Given that those tracking devices are timestamped, are you able to make a visualization of that data?
I am.
And would you recognize a visualization of Avery Becker's data from March 6th?
Yes, sir.
Would the timekeeper please share Exhibit 16? Detective Markowitz, is this a fair and accurate representation of Avery Becker's data from March 6th?
Yes, it is.
And briefly, before we admit this evidence, could you describe what this black dotted line is?
The black dotted line is one of the paths Avery Becker took to get from the area around her house to the area around Coach Brackman's house over the course of the day and in the time frame close to the interview.
Defense, what's your reason for objection?
I object speculation because the witness does not have a basis in personal knowledge of Ms. Becker's whereabouts, and they did not establish that their opinion was based on their expert review of the evidence.
Prosecution, do you have a response?
Your Honor, the court has previously recognized that Detective Markowitz is an expert in cell phone or forensic cell phone data recovery and analysis. His description of the line that he has drawn here based on the evidence that he collected from Avery Becker's phone would fall under cell phone data recovery and analysis and is therefore not speculation. It falls under an expert opinion pursuant to Rule 702.
Defense, do you have anything else?
Yes, Your Honor. Detective Markowitz said something along the lines of, "This is where Avery Becker traveled." He did not, however, say that based on his expert opinion and his review of the evidence that this is what he inferred. He was simply speculating as to the whereabouts of Miss Becker.
I'm going to sustain the objection. Prosecution, continue to lay a foundation for this.
Yes, Your Honor. Detective Markowitz, did you analyze Avery Becker's phone data from March 6th?
Yes, I did. And this dotted line here is where I was able to track Avery Becker's cell phone as it was connecting to these cell towers. And I had that information based on the data I collected.
Is this dotted line that you created based on your expert analysis of these 3 CDR data points?
Yes, sir.
And do you commonly do this type of analysis for court proceedings, including criminal court proceedings?
Yes, sir, all the time.
The prosecution now moves to admit Exhibit 16 into evidence.
Defense, do you have an objection?
No objection to Exhibit 16, Your Honor.
We'll admit into evidence Exhibit 16. Prosecution, continue.
Detective Markowitz, are CDR records reliable?
Yes, they are.
How reliable?
Well, it gives me a guaranteed contact between a cell phone and a cell tower, and allows me to pinpoint the exact time in which that contact was made. However, unfortunately, I can't pinpoint an exact location of the cell phone, only a general area.
Are these analysis of cell phone data often used to pinpoint criminal positions in criminal court proceedings?
Yes, they are.
And are they well relied on in a court?
Yes, sir.
Now, based on your expert analysis of all of the data, as well as the CDRs that you collected, where do you believe Avery Becker was on March 6th?
Based on all of the evidence I collected in this case, from the ring video to the CDRs, from the text messages between Avery Becker and Alex Fuentes, I am confident that Avery Becker was the one who committed this crime on the day of March 6th.
Thank you very much, Detective. Thank you, Your Honor. I have no further questions for this witness at this time.
You may cross-examine the witness, please.
Thank you, Your Honor. Good afternoon, Detective Markowitz. My name is Olivia Moraine, and I'm going to ask you a few questions. You arrived at the scene of the murder and noticed a body just inside the front door, right?
That is correct.
And after confirming their ID, you recognized this person, didn't you?
Yes, I recall that they were Mackenzie Braxton.
And you had testified in trials against his clients, didn't you?
That is correct.
So upon realizing the body was Mackenzie Brackman, you thought it possible that he was killed by a, quote, disgruntled ex-client. Is that right?
I considered that as a possibility, yes, ma'am. However, I followed the facts of the case, and in this case, they led me a different direction.
So you never followed up on this theory, did you?
No, as an expert in this field, I didn't see a need to.
You instead formed your opinion based on what you deemed the first big break in the case, right?
Yes, ma'am.
I would like to direct your attention to this first big break. You used forensic software to download the contents of Mackenzie Brackman's phone, right?
That is correct.
So this technology that has the capacity to download the contents of a cell phone was available to you throughout the course of this investigation, wasn't it?
Yes, ma'am.
But you didn't use this technology to examine the contents of Alex Fuentes' phone, did you?
I didn't see a need to.
I would like to direct your attention to what's been previously admitted as Exhibit 14. Are you familiar with Exhibit 14?
I would assume I'm familiar with it, but it'd be better if I had a visual of that to help.
Would my co-counsel please screen share Exhibit 14 for Detective Markowitz? So I'll re-ask, Detective Markowitz, are you familiar with Exhibit 14?
Yes, ma'am, I am.
And you received these images of what appear to be screenshots of text messages from Alex Fuentes following an interview with them, correct?
That is correct.
But you never saw these text messages directly, did you?
No, unfortunately, Mr. Cifuentes left his cell phone at his house. I mean, the stress of going into a police interrogation can be a little bit overwhelming.
So you accepted these images from Cifuentes a day after your investigation, didn't you?
That is correct.
And you didn't ever actually confirm the validity of these messages, did you?
I didn't see a need to. Screenshots are relied upon all the time, and as an expert in the field, I rely upon them heavily.
But you did use these messages to help you form your opinion about the case, right?
Absolutely.
You even saw these messages as the biggest break in the case, didn't you?
They were one of them, yes.
So you used evidence that you just have confirmed is unverified to form your theory against Avery Becker, didn't you?
I would be hesitant with that. I am very trusting in my abilities as an expert, and I believe to cast doubt upon Mr. Cifuentes is interesting.
That's not my question. I'm simply asking if you used Exhibit 14, which you have confirmed you did not verify, to form your theory against Avery Becker.
I did use Exhibit 14, but I didn't see a need to verify it as an expert in the field.
I would now like to direct your attention to the part of your investigation that focused on the call detail records. You reached out to Avery's attorney to obtain a warrant to search the phone of Avery Becker, correct?
That is correct.
But you were told this was impossible because Becker lost the phone on March 5th, correct?
Yes, I was informed of that.
So while you conducted your analysis, you knew that it was possible that Avery had lost their phone, correct?
I was aware of that as a possibility. Yes, ma'am.
Yet from this point on in your statement, you refer to the position of the phone as the position of Avery, correct?
Yeah, that is correct. I rarely see a teenager without their phone these days.
But Avery and her phone are actually two different things, aren't they?
Yes, they are. You're right in that.
So you just assumed them to be the same entity, didn't you?
Like I stated, I rarely see teenagers without their phones. And so
that-
yes, I did.
Let's move to the various calls and texts between Becker's phone and Perkins's phone. Your CDRs confirm that there was cell communication between the phone of Becker and the phone of Perkins, right?
That is correct.
And the duration of these phone calls was extremely short, correct?
That is correct.
So short that there was likely no connection between Avery's phone and Taylor's phone?
Yes, ma'am.
So in other words, Avery didn't pick up the phone.
No, I don't believe so.
But you don't know why she didn't pick up the phone, do you?
No, I do not.
In fact, it's possible that Avery didn't pick up the phone because they didn't have the phone, isn't it?
It is a possibility, yes.
Thank you, Your Honor. No further questions.
Your Honor, I believe that you are muted. Before I ask for a redirect, I would ask the timekeeper for a brief time check.
Yes, the prosecution has 5 minutes and 18 seconds left for direct.
I have no redirect, Your Honor.
Prosecution, would you like to call your third witness?
Yes, Your Honor. The prosecution calls Ms. Kyle Kuzak to the stand. May I proceed?
Yes, please.
Ms. Kuzak, are you a certified crime scene reconstruction investigator?
Yes, I am. I'm certified by the Colorado Bureau of Investigation.
What exactly does that mean?
So a crime scene reconstruction investigator, also known as a CSR, basically we go to the crime scene, we analyze all of the evidence that we see at the crime scene, and then we reconstruct the crime scene so that we can tell everyone how the crime occurred.
And what kinds of evidence do you look at?
I look at any evidence. I look at murder weapons. I look at biological and physical evidence. I look at security and home security footage. I look for signs of altercation. I look at everything.
And about how long have you been working as a CSR?
I've been a CSR for 19 years. The most recent 3 have been on a tenure with the City of Denver.
Thank you, Ms. Kuzak. Your Honor, the prosecution at this time moves to tender Ms. Kyle Kuzak as an expert in crime scene reconstruction with special emphasis on biological evidence and home security systems.
Defense?
Permission for a voir dire.
Yes, go ahead.
Ms. Kuzak, you are not a police officer, isn't that correct?
That's correct. I'm a crime scene reconstruction investigator.
And you only have a certification in crime reconstruction, right?
I'm certified as a crime scene reconstruction investigator. Through that, I look at anything that revolves or relates to a crime scene.
So you don't have a degree in crime reconstruction, do you?
I'm sorry, I don't have a degree. I am certified. In order to be certified, I go to the required schooling.
But you didn't go to school for this specific job. You just completed a certification, correct?
I am certified, yes.
Your Honor, based on the witnesses' responses and their admission that they do not have a formal degree or education in crime scene reconstruction, they should not be qualified as an expert in crime scene reconstruction in this case.
I'm going to find that Ms. Kuzak is qualified to testify as an expert in this case in terms of crime scene reconstruction because she is certified as a crime scene reconstruction. Go ahead, prosecutor.
Yes, Your Honor. Now, Ms. Kuzak, did you hear the defense's opening statement?
Yes, I did.
Did you hear them ask the question, how reliable was the police investigation?
Yes, I did.
How do you conduct a reliable investigation?
I follow a procedure. I follow a 5-step procedure. The steps are the recognition and documentation, then the collection of evidence. Following that, I evaluate the evidence. find a hypothesis, test that hypothesis, and then eventually reach a final conclusion.
And you did this for this case?
I did.
Did you create any documents while you were following through your 5-step procedure?
Yes, at the beginning, I created a spreadsheet and filled it in. I've created two spreadsheets. I created a witness tracking spreadsheet and an evidence tracking spreadsheet. And then once I reached my final reconstruction, I created a flowchart.
Timekeeper, if you could please share Exhibit 17, the first slide. Ms. Kuzak, is this a fair and accurate copy of your flowcharts and spreadsheets?
Yes, it is.
Now, did you make these at or near the time of the crime?
Yes.
With information transmitted by people who were knowledgeable about the crime?
Yes.
And do you do this in the course of your professional work?
Yes.
Is it regularly made?
Yes, it is.
Is it regularly kept?
Yep.
Is everything based off of your professional opinion?
Yes, it is.
Now, are there summaries of police interviews?
Yes, there are.
Were those interviews recorded at or near the time they were taken?
Yes.
Were those interviews made in regular police practice?
Yes.
Were those interviews kept in regular police practice?
Yes.
And for the flowchart, when you refer to intent, do you refer to it in terms of the charges in a legal sense?
No, I do not.
Thank you, Ms. Kuzak. Your Honor, the prosecution moves to admit Exhibit 17 into evidence.
Oh, Your Honor.
Objection.
Yes, Your Honor. Objection over Rule 801 hearsay. This is an out-of-court statement that is offered for the truth of the matter.
May I respond, Your Honor?
Go ahead.
Your Honor, I have laid the proper foundation under Rule 8036 that these spreadsheets and flowcharts themselves are a business record. Furthermore, hearsay within hearsay is permitted under Rule 805 as long as each specific section of hearsay has its own exception. Now, I have also laid the proper foundation for the police interviews that are summarized under Rule 8036, again, a business record. Furthermore, there are statements made by Taylor Perkins and by the defendant. These statements are admissible and they are not hearsay pursuant to Rule 801D2A and E. A statement made by opposing party, and B, and E, a statement made by a co-conspirator in furtherance of the conspiracy. It is the prosecution's theory of the case that Taylor Perkins conspired with Avery Becker.
I'm going to overrule the objection. This is a document, this is a business document created in the course of business, and I'll allow it into evidence. I'm going to admit it as Exhibit 17 into the evidence. Proceed, Ms. Davidson.
Yes, Your Honor, and pursuant to the pretrial matters, this is constructively published to the jury?
Yes.
Thank you, Your Honor. Timer, if you could please stop screen sharing. Ms. Kuzak, can you walk us through what happened to Mackenzie Brackman using the flowchart?
Yes, the flowchart is divided into 4 columns. The first column, the intruder approaches and attempts to enter the home. The intruder tries the front door, he finds it locked, goes around the side, and enters through the back door.
Was Mackenzie Brackman alerted to the presence of this intruder?
Yes, Brackman was alerted either via notifications he would have received from his Ring doorbell or from the noise that the back door makes. Either way, he was aware of the intruder when the intruder entered his home and went to receive a knife from his kitchen to meet the intruder at the back door.
So you were saying that Mackenzie Brackman had the knife. Why is that important?
Well, Brackman brought the knife into the situation. The intruder, when he was approaching the home, he was intending to break and enter. There was no intention shown for murder. There was never a knife in any of the videos. Brackman brought the knife into the situation and the scuffle followed that.
What biological or physical evidence points us to the scuffle?
There is scuff marks near the back door. There's a plate that appears to—
Objection. Relevance.
May I respond, Your Honor?
Yes.
Pursuant to Rule 403, relevant evidence makes any fact of the case that is a controlling fact more or less probable. Now, today it is the prosecution's theory of the case that Avery Becker, driven by Taylor Perkins, went to the scene of the crime. At the scene of the crime, Ms. Becker attempted to enter through the front door, finding it locked, went around the side to attempt to break into the back. Once she had broken into the back, she was met by Mackenzie Brackman, who had a knife. Then, in the following scuffle, Ms. Becker won the knife and stabbed Mackenzie Brackman. Now, the fact that there was a scuffle and the scuff marks and broken plate that point to this scuffle makes the fact that Avery Becker caused the death of Mackenzie Brackman more probable. Now, that goes directly to a charge, a controlling matter, and therefore is admissible relevant evidence under Rule 403.
Your Honor, can I please respond?
Yes.
Scuff marks could occur or be made at any time, and there is no way to tell when these scuff marks were created. And under Rule 901, this witness has not established that these scuff marks are a result of a struggle with Brackman.
May I respond, Your Honor?
No. I'm going to sustain the objection. This is not relevant evidence. I agree with Ms. Davies that we don't know when these marks were left. Ms. Davidson, please proceed.
Yes, Your Honor. Ms. Kuzak, what other evidence do you have that the scuffle occurred?
There was blood spatter. There are drops of blood from when the knife entered, moving towards where the body is, and then there was spatter on the walls and the ceiling from when the victim pulled the knife out of his back.
So you know that the intruder stabbed Mackenzie Brackman?
Yes.
And you know that the defense plans to offer Professor Van Owens as their expert. Briefly,
Yes.
Do you have any words about or for the professor?
If Van Owen does an actual and full reconstruction of this case, I'd love to have a conversation. Until then, there's nothing I can do.
Thank you, Ms. Kuzak. Thank you, Your Honor. I have no further questions for this witness at this time.
Does the prosecution have any other witnesses?
Your Honor, I believe that there is a cross-examination next.
Oh, sorry. Defense, do you have cross of this witness?
Yes, Your Honor. Thank you. Hello, Ms. Kuzak. My name is Audrey Davies, and I'm going to ask you a few questions tonight.
Okay.
You testified that you are a crime scene reconstructor who investigated this case, correct?
I am a crime scene reconstruction investigator, and I did do this case, yes.
But you are not the first investigator on this scene, correct?
That is correct. I came after the police had processed the scene.
In fact, you did not arrive on the scene until other investigators had processed the entire crime scene.
Yes, I just said that.
So you were not the one who processed the scene directly, correct?
I don't process scenes. I come to the scene after the police process it, and then I look at all the evidence and I go about reconstructing the crime scene.
So in order to do your crime reconstruction, you're relying on the crime scene processing that other people completed. Isn't that correct?
My reconstruction doesn't rely on the processing that the police do. The police process because it is part of their procedure. I go to the crime scene so that I can look at all the evidence in person, and then I, having looked at all the evidence, make the flowcharts and reconstruct the crime scene from there.
That's not exactly my question. Other investigators process the scene, and you are using the information that they processed in order to complete your job. Isn't that correct?
I'm sorry. I don't think we're on the same page here. When people process a crime scene, they're looking at the crime scene and they're basically being like, so this broken plate was here. When I reconstruct a crime scene, I go to the crime scene. I look at that broken plate. I don't rely on someone else to tell me that. I go to look at it.
No, but you're relying on the crime scene processing that other people completed. Correct?
No, but sure.
So since you didn't process the crime scene directly, you can't guarantee with 100% that the crime scene was processed with 100% accuracy, can you?
I'm sorry. My job, it's not my expertise to process a crime scene. My job is to go to the crime scene, to look at all the evidence that I see at the crime scene and look at all of the outside evidence, like the interviews, and then reconstruct the crime scene from there.
That's not my question. You can't guarantee with 100% certainty that this crime scene was processed, that this crime scene process was completely accurate with 100% certainty.
No, I can't, but that's
Thank
also
you.
not something that I do.
You believe, moving on, you believe that you would have wanted more evidence. Is this correct?
Yes, I always want more evidence with my cases.
And the evidence you would have wanted includes DNA and fingerprints. Isn't that correct?
Yes, we only were able to get DNA from the blood of Brackman at the home, but that makes complete sense considering on the ring videos we see the intruder wearing gloves.
And the fact is that you don't have a single piece of concrete physical evidence that connects Avery Becker to this crime scene, do you?
No, but I don't. My goal when I reconstruct a crime scene is not to place someone at the scene and like be able to tell people who did it. My job is to tell you how the crime occurred. I'm able to tell you that an intruder entered the back door, and then from there, the intruder was able to gain control of a knife and stab Brackman in the back, and then the intruder left.
So that's a no.
That's correct.
Now let's address the potential evidence that was destroyed. The pictures of the blood droplets.
Okay.
You testified that you saw pictures of blood droplets on the way out of the kitchen towards the hallway, as well as blood splatter on the walls. Isn't that correct?
Yes, I was able to see that.
And you reviewed these photos, right?
Yes, but I was not relying on the photos. I was relying on the physical evidence that I saw at the home.
However, after you viewed these photos, the photo files were corrupted. Isn't that right?
Yes.
And so nobody, including the jury, can see this evidence today, can they?
No, the jury can't. But my final reconstruction, my whole reconstruction was not based off corrupted photos. It was based off the evidence that I saw at the crime scene.
And so without these pictures today, nobody can attest the information that you're claiming is true regarding these photos, can they?
No, they can't. But as an expert and as a reconstruction and as a CSR, my job isn't to guarantee whether or not the photos work. My job is to reconstruct the crime scene.
That's a no, correct?
Yes, I already said that.
Let's discuss the videos that are marked as Exhibits 13. You mentioned that while you were you watched these videos when investigating the crime scene, correct?
I'm sorry, what is video 13?
May my co-counsel please share Exhibit 13 for Ms. Kuzak? Essentially, they're already admitted into evidence, but
if you wish, my apologies, Ms. Davies. My timer would be perfect. Oh, there we go.
Thank you.
Yes.
Okay. And you watched these Ring cameras, correct? Camera videos, correct?
Yes, I did.
And in these videos, you can't actually see the perpetrator's skin color or face or hands, can you?
Objection, Your Honor. This is a compound question. I would just ask that opposing counsel break it out.
Counsel, please,
Yes.
Please break those questions down.
Of course. In these videos, you can't actually see the perpetrator's skin color, can you?
That is correct.
And you can't see their face?
That is correct. They're wearing a mask and clothing.
And you can't see their hands either, can you?
That is correct. They're wearing gloves.
Nor can you determine this person's gender?
Correct.
In fact, the videos don't show a single distinguishing characteristic about the perpetrator, does it?
The perpetrator we see enter the home. The only thing that would relate the perpetrator back to the defendant is that they have a similar build and height.
But this general build and height also relates to a very large population of people in this world who aren't the defendant, isn't that correct?
One would assume, yes.
So you don't really know that the person in this video is Avery Becker, not with 100% certainty.
I don't, but again, my job is not to connect a perpetrator to a defendant or to any suspect. My job is to tell you how the crime occurred at the crime scene.
Thank you. No further questions.
Ms. Davidson, do you have a redirect?
No redirect required, Your Honor.
Okay. Mr. Lish, does that complete your case in chief?
Yes, Your Honor. The people rest.
Thank you. Defense, would you like to call your first witness?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Proceed with questioning.
Good afternoon, Professor Van Owen. My name is Olivia Moraine, and I'm going to ask you a few questions. To begin, please state your name for the jury.
Of course, my name is Blake Van Owen.
And what is your current employment?
I'm a private investigator.
And do you have any experience in the field of law enforcement?
Yes, I do. I joined the Aurora Police Department back in 2005. After that, I worked as a school resource officer, next went into private security, and finally settled on private investigation.
And have you received any specialized training or education in the field of law enforcement?
Yes, I have. I've received a master's degree in criminal justice through the Ashford University's online program.
And have you testified as an expert witness before?
Absolutely. I've testified in over 100 law enforcement related cases, 5 of those being closely related to cell tower evidence, which is very pertinent to this case today.
And what are your specific areas of expertise?
Well, in addition to my job in education, I consider myself an expert in the areas concerning police practices, use of force, false arrest, as well as forensic evidence techniques. In that respect, I have been qualified as an expert in the states of Colorado, Arizona, Kansas, Nebraska, as well as New Mexico.
And have you ever had any adverse issues related to your employment as a police officer?
Yes, a while back, there was a civil suit filed against me for use of force. They did conclude that there was no wrongdoing on my part, however, and ultimately that experience just taught me that there are many ideals and ideas that the police believe in criminal justice that I don't necessarily agree with.
The defense respectfully requests that the court qualify Blake Van Owen as an expert in the areas of police practice and forensic evidence techniques.
Your Honor, may the people perform a brief voir dire?
Yes.
Good evening, Professor. I'd like to talk just a little bit about your experience with CDR data. Now, in your witness statement, you don't mention the name of a specific class you took regarding CDR data.
Right. I have a master's degree in criminal justice, and the rest of my experience in the field was established through experience.
So let's talk about that experience. Now, you've investigated hundreds of cases.
Right.
And you were qualified as an expert in CDR data 5 times.
That's correct.
Now, Your Honor, I would ask the court to take judicial notice pursuant to Rule 201 that 5 divided by 100 is 0.05, and 0.05 in a percentage is 5%.
Are you asking me?
No, that is a petition for the court.
Oh.
Notice of the math. Go ahead.
So you've only been qualified as an expert in CDR data 5 times. Sorry,
right,
5.
Well, only 5. Yeah, that's correct. Only 5 times, and 5% of my cases have been closely related to cell tower evidence where it was necessary that I was qualified in that area.
And you don't mention any specific training you've ever had in CDR data.
Right. That training ultimately came in my past when I was working in the field of criminal justice. You encounter many cell tower evidence.
That wasn't my question, Professor. My question was, do you specifically name any training courses that you've taken regarding CDR data?
Right. I have a lot of experience, but no official formal degree or training in that area.
Thank you, Professor. Your Honor, if I may be heard with my objection now.
Yes. Go ahead.
Pursuant to Rule 702, first, I would like to say that I have no objection to this witness's qualification under general police procedure. My only objection is with the CDR qualifications. Pursuant to Rule 702, an expert witness must have skill, knowledge, education, experience, or training. Now, the professor has not demonstrated her skill, has not demonstrated her knowledge, has not demonstrated her education, has not demonstrated her training, and therefore, she has and not demonstrated her specialized knowledge. Now, this goes to show that she is not qualified pursuant to Rule 702 to be an expert in CDR data.
Your Honor, may I briefly respond? Given Professor Van Owen's extensive experience and training in the field of law enforcement and her master's degree in criminal justice from the Ashford University's online program, she possesses the necessary knowledge, training, and skill to be qualified as an expert. And should her testimony move into CDR data, which is not one of the areas for which I was initially trying to qualify her, under Rule 703, she is allowed to base her expert opinions based on evidence that she would normally reasonably use in her field.
May I respond, Your Honor? Your Honor, I'm having a little bit of difficulty hearing you.
Oh, go ahead. Sorry.
Thank you. Your Honor, I would ask that we move into Rule 703 when we get there. 703 is for already qualified experts. As I have said, I have no objection to her qualification under police practices, police matters. I would just ask that the testimony not stray into CDR data if she is not qualified in that area.
Ms. Moraine, do you plan to question the professor on CDR data?
Yes, Your Honor. Professor Van Owen will talk briefly about her interpretation of the findings collected by Detective Jordan Markowitz that are cell phone data, but as an expert in the area of forensic evidence techniques, she possesses the necessary experience, training, and knowledge to analyze the data collected by Jordan Markowitz.
I'm going to find that the professor is qualified to testify as an expert in police practices and forensic evidence. And she may testify, and she is an expert in the CDR data based on her education, experience, and knowledge. Please
Yes.
proceed.
Thank you, Your Honor. Professor Van Owen, please tell the jury about your connection to this particular case.
Of course. Well, I was contacted by the defense to conduct a follow-up investigation because they had indicated to me that there was some evidence that the police department overlooked in their investigation.
And were you paid to work on this case?
I was. This is my job, and like any other job, I'm paid as a professional for my time. I absolutely was not paid to give any particular opinion here today.
And what did you do to prepare for this case?
I have reviewed the police reports, Kuzak's crime scene reconstruction, the cell tower records, as well as the exhibits that Markowitz prepared. To that extent, I also have taken a photograph to represent a common way that a knife is held.
I'd like to direct your attention to the part of your investigation that focused on the cell phone data analysis. To begin, please explain your findings related to the cell phone data in the investigation.
Of course. So when I looked into the cell phone data, I found that Avery's phone was in fact connected to a tower near Brackman's house at the time of the murder. However, given the inconsistencies and lack of precision in cell tower evidence, I considered this data circumstantial, to say the least.
And how did your investigation of the cell towers differ from that of Detective Markowitz?
Well, in my opinion, Detective Markowitz was not thorough at all. He was very selective in the records that he chose to obtain and those that he didn't. It appeared that he was only looking into records that would incriminate Avery later on.
And based on your knowledge of the case, which records did Detective Markowitz not obtain?
Well, Detective Markowitz did not look into any of Alex Fuentes or Blair Rollins' cell phone records, which could have possibly indicated of an alternate suspect. And to that extent, he also did not look into Taylor Perkins' cell phone records, which could have further legitimized Avery's alibi.
So based on your professional knowledge and expertise, what opinion did you form about the cell phone evidence in this case?
In my opinion, the evidence regarding the cell phone towers is inconclusive and should not be a vital piece of evidence to this case. It's also clear that the evidence is consistent with Avery's statement that the phone had been stolen earlier that day.
I'd now like to direct your attention to your investigation of the intrusion into Coach Brackman's home. In your investigation into the intrusion, what did you review?
I looked into Coach Brackman's autopsy report as well as the pictures of Coach Brackman's residence that were taken. I additionally looked into the videos that were downloaded from the Ring doorbell system. To that extent, I also took some of my own photos of a way that a knife is likely to be held.
I would like to ask Professor Van Owen to please direct her attention to Exhibit 21. Are you familiar with this picture?
Yes, I took this photo as part of my investigation.
And is this an accurate representation of the picture that you took?
Yes, it is.
Your Honor, may I please have permission to admit what has been marked as Exhibit 21 to evidence?
Can you put that up on the screen?
Yes, would my co-counsel please share Exhibit 21?
Prosecution, do you have any objections?
Yes, Your Honor. I would object under 401 relevance. The knife in this picture is an entirely different make and model, and therefore how it may or may not be held in a picture is irrelevant to how it may have been held, to how the knife in this case may have been held.
Defense, do you have a follow-up?
Yes, Your Honor. It was indicated in Professor Van Owen's witness statement that the make and model of this knife is similar to that which was used in the murder. And it's very important to the case because it aids the jury in their understanding of of Professor Van Owen's theory about what really happened on the day of March 6th.
Prosecution?
Your Honor.
Further, go ahead.
Your Honor, I withdraw my objection, but would like to remind the jury that I will cover this during cross-examination.
Okay, I will admit into evidence Exhibit 21 and publish it to the jury. Proceed.
Thank you. Professor, what does this photo show?
It shows a common way that a knife of a similar magnitude to the murder weapon is likely to be held.
And according to your expertise, what is the most common way for it to be held?
Well, as you can see in the picture, there are grooves on the knife, and these are meant to mirror the shape of your fingers. So if your fingers are laying in those grooves, the blade of the knife will be facing upwards. And so in my professional opinion, it is most comfortable and most natural for the knife to be held with that blade facing up.
And why does the position of the knife matter?
Well, based on my review of the autopsy report, the stab wound found in Coach Brackman's back came from an upwards angle. So if the knife was being held as I suspect it was being held, once again with your fingers in those grooves, the prosecution's explanation of a struggle that then resulted in the stabbing is inconsistent with the forensic evidence.
How so?
Well, for Coach Brackman to have died during a struggle, as Markowitz concluded, the perpetrator and Mr. Brackman would have to be facing each other, and the perpetrator would have to reach over Brackman's back to stab him that way. This would require the perpetrator to be significantly larger than Coach Brackman.
And why is this a problem?
Well, this is not only inconsistent with Avery's height, but it is also inconsistent with the height of the perpetrator that we can see on the Ring videos.
So what then, according to your professional knowledge and expertise, do you think happened?
Well, in my professional opinion, as well as my review of all the evidence, I believe it makes far more sense that Coach Brackman was sitting with the intruder standing behind him, holding the knife, once again, as I suspect. And it is additionally very unlikely that Mackenzie Brackman was aware of the intruder or confronted the intruder.
And why does it matter if Coach Brackman is sitting with the intruder standing behind him?
Well, because if Coach Brackman is sitting, it negates the prosecution's theory that Coach Brackman surprised the intruder, and a struggle then ensued.
Thank you, Your Honor. I have no further questions, and I pass this witness for cross-examination.
With your cross-examination.
Yes, Your Honor. If my timer could please project Exhibit 5. Professor, you looked at every bit of evidence in this case?
That's correct, yes.
And that includes this photograph.
That is correct.
Is there an accurate photograph of the actual knife that was used at the scene?
Right, that's the murder weapon.
Your Honor, the prosecution moves to admit this exhibit into evidence.
Defense, any objection?
Yes, Your Honor. Professor Van Owen lacks foundation to authenticate this or to admit this exhibit into evidence because she did not take the photo, nor did she see the photo firsthand, and she therefore cannot, there is not adequate foundation for this exhibit to be admitted under Professor Van Owen.
May I respond, Your Honor? Pursuant to 901, a qualified witness may authenticate an exhibit. I have asked, is this the photo that you examined in your analysis? This witness has said that pursuant to my professional analysis, and I've looked at all of the evidence, and therefore this witness is qualified and has in fact drawn their conclusions on this knife. Now, if this witness doesn't have the foundation to admit this exhibit, therefore not the foundation to testify about this knife, I would ask that the majority of her previous testimony be stricken, as she's not qualified to give that either.
I'm going to find that, first of all, I'm going to overrule the objection, and I'm going to admit Exhibit 5. She did use this in her analysis, and go ahead with your examination.
Yes, Your Honor. Now, Professor, this has a different handle than the knife you were holding.
Right, it doesn't have the exact handle, but it has a similar groove to it that was similar to the one that I was discussing.
And you've never held this knife?
I haven't, no.
You've never actually seen it in person?
That's correct. I looked at all the evidence that was already taken, the photos, etc. I was never at the crime scene firsthand.
But you assume that it's similar to hold this knife as it is to hold your personal knife?
Well, it is clearly very similar in the make of the knife. You can see that without holding the murder weapon firsthand.
All right, Professor. So let's move on and talk about what we agree with. Now, specifically what we agree with regards to the whereabouts. Timer, if you'd please stop the share, thank you. Specifically what we agree with about the whereabouts of Avery and Taylor on March 6th. Now, you agree that they both weren't at school.
That's correct. They were looking for Avery's phone, as Avery had said.
And you agree that they were both together.
Yes, that's correct.
Now, I'd like to move on to what we agree about with regards to evidence. Now, you agree that a passing motorist called 911.
Yes, that's correct.
And you agree that this passing motorist reported Mackenzie Brackman lying on his porch.
Yes, there is no evidence that indicates otherwise.
Now, you also read Taylor Perkins' statement.
That's correct.
And you're aware in Taylor Perkins' statement that Taylor says Brackman was lying on their porch.
Right.
Timer, if you could please project Exhibit 13. Now, you reviewed this video?
I did.
And in this video, you can see a brick wall.
That's correct. Yes.
You can't see a street.
Right.
Not to the right.
Yes, that's correct.
Not to the left.
Yep.
Not in front.
Right, that's correct.
And you can't see any motorists.
Right.
So as far as you know, based on this video, the only way to see Mackenzie Brackman's body on the porch is to be in the backyard or in the neighbor's backyard.
We don't necessarily know that. We are only looking at one angle of the camera. Obviously, if you shifted the camera around, we would have a different view, not necessarily just the brick wall. So no, I don't think that's what this indicates.
But Professor, let me clarify now. You've never, ever been to the scene, right?
That's correct.
So as far as you know, this is the only knowledge about the property that you've seen.
Right, but I don't think we should look at one video piece of evidence and conclude that that's exactly, that says everything about the physical layout of the house.
All right, Professor. So now I'd like to move on to, and Timer, you can stop the share. I'd like to move on to what we agree with about the crime itself. Now, you do agree that someone broke into Mackenzie Brackman's house,
Right.
and you agree that that person was wearing a mask.
Right. That's correct. We can see that on the Ring doorbell video.
Probably trying to hide their identity from Mr. Brackman.
Right. Or anything, hide their identity from the Ring doorbell video, etc.
And you agree that that person broke in,
Yes.
and that person stabbed and murdered Mackenzie Brackman.
Right.
Now, the main thing that you disagree with is who that person was.
That's correct. Who that person was and how the murder took place.
So let's talk just a little bit about why you disagree with who that person was. Now, you view yourself as a check on the power of policing.
I think it's important that there are multiple sets of eyes looking at a given situation. And I think the police department is not necessarily always right. So it is important that you get third parties to look at a crime scene and give their opinion. And so, yes, that's what I did.
That's not what I asked. You submitted a statement in this case.
I did.
And in that statement, you call yourself a check on the power of policing.
Right. That's one way to say it. I'm essentially just making sure that the police department is doing their job.
You're a sort of social justice warrior.
I mean, that's a very nice way to put it, but I essentially just try to find justice.
A social justice warrior that gets paid.
Right. I get paid as well as, every other crime scene investigator on this given case. It's my job. And so, yes, I get paid for my expertise.
Yes or no, in your witness statement, you say that you make a pretty decent living finding where the police have dropped the ball.
Yes, I'm happy with what I make.
And you're paid by defendants.
Right. Unfortunately, defendants don't often have the same police resources that the prosecution has. And so I'm there to kind of provide that third set of eyes and, look into where the defense thinks that the police has dropped the ball.
Yes or no, you're paid by Avery Becker?
Yes, that is correct.
And yes or no, you're going to make $8,000 in this case.
I don't know the exact number, but that sounds correct.
Now, I'd like to talk about a little bit about what you did and didn't do while earning that $8,000. Yes or no, you never went to the crime scene?
Right, I didn't. I looked at the evidence that was provided to me by the detectives that were on that case.
Yes or no, you never interviewed a witness in this case?
That's correct.
Yes or no, you never downloaded any new phone-related data?
Right. Once again, my partial investigation covered looking into the data that the police department had already collected.
And let's talk about what you did do. You did read some reports, right?
I did. I read all the reports thoroughly. I looked at all the exhibits. I looked at the Ring doorbell videos, and I covered the entire crime scene very thoroughly.
And you looked at some attendance records?
Right, including those of Blair Rollins, who was missing the day of the murder as well, and the police department never looked into her.
That's not my question. You just looked at some attendance records, right?
Right, including those of Blair Rollins.
Thank you, Your Honor. I have no further question for this witness at this time.
Defense, do you have a redirect?
Yes, Your Honor.
Go ahead.
Professor Van Owen, does the fact that you were paid to work on this case compromise your ability to form an evidence-based opinion about the case?
Absolutely not. I pride myself in finding the areas where other investigations have gone wrong, and I think justice is ultimately the most important end result. And so, no, my getting paid has nothing to do with my conclusion.
And does the fact that you work primarily for the defense prohibit you from forming an evidence-based and unbiased opinion about the case?
Once again, absolutely not. There are plenty of cases where I don't necessarily think there are discrepancies between my idea and that of the prosecution. In this given case, however, I was very disappointed in how the police department handled the investigation.
Thank you, Your Honor. No further questions.
Defense, do you have would you like to call your second witness?
Yes, Your Honor. The defense would like to call Mr. Taylor Perkins to the stand.
Proceed with questioning.
Please introduce yourself to the jury.
Hello, my name is Taylor Perkins.
Mr. Perkins, do you know someone named Avery Becker?
Yeah, I know Avery. She's my best friend.
Do you also know someone named Alex Fuentes?
Yeah, I know Alex.
Please tell the jury who Alex is.
Alex was one of our teammates on the mock trial team.
How would you describe Alex's personality?
Well, Alex just has this way of being like totally insincere in a kind of passive-aggressive way.
Do you know if Avery and Alex know each other?
Yeah, I mean, we were all on the mock trial team together, so yeah, they know each other.
Can you describe the relationship between Avery and Alex from what you observed?
Well, I knew Avery pretty well enough to know that she and Alex really never got along. I mean, they were always fine on the surface, but deep down, they weren't friends at all.
Now, moving on to your mock trial team. Were you on the mock trial team at Colorado High School?
Yeah, I was.
How long have you been on the team?
I was on the team for a pretty long time.
Did there come a time when you were no longer on the mock trial team?
Yeah, I ended up stepping down after my friend Avery got demoted.
Did you ever run into the mock trial team outside of school?
Well, yeah, I mean, we went to the same school together, so we would see them there. But there was this one time on the Fry Shack on March 5th that was especially bad.
What happened on the evening of March 5th at the Fry Shack?
Well, Avery and I had gone there to go get some food, but it ended up being a pretty bad idea because the whole mock trial team went there after practice, and it got kind of awkward.
Can you explain the interaction between Avery and Alex that day from what you observed?
Well, yeah, Avery and I were sitting at our table, and Alex came over, and she was doing that, their passive-aggressive kind of way of talking to us, and it really got to Avery. So much so that Avery ended up storming off to the bathroom without her phone, which is so not like her.
What happened after Avery went to the bathroom?
Well, I had to hold conversation with Alex for a few minutes, and then when Avery came back out, we left.
When was the last time you saw Avery's phone?
The last time I saw Avery's phone was sitting on the table at the Fry Shack.
Did you look for Avery's phone?
Yeah, the next day we ended up retracing our steps to see if we could find the phone, but we couldn't find it anywhere.
So can you explain to me a little more? Where were you and Avery on March 6th?
Well, that morning, Avery had picked me up to take me to school, but we realized she didn't have her phone, so we ended up retracing our steps from the day before to try and find it. We went to the Fry Shack, we went to the mall, and went through all the stores we had been at before, but we just couldn't find it anywhere, and we ended up burning the whole day.
Was Avery Becker near Mackenzie Brackman's house on the day he was killed?
No, Avery Becker was nowhere near Mackenzie Brackman's house.
Are you sure?
Positive.
How are you sure?
Because Avery Becker was with me.
Now, moving on, do you know someone named Blair Rollins?
Yeah, I know Blair.
How do you know Blair?
Well, we go to school together.
What do you know about Blair?
Well, everyone that knows Blair knows she's a little off, just has that little unhinged kind of deal going with her.
Simply based on your personal observations, do you know if Alex and Blair know each other?
Yeah, from what I could tell, they were actually pretty good friends.
And based on your observations and from what you personally know, did Alex and Blair have anything in common?
Well, from what I know about both of them, they both had reasons to hate Mr. Brackman.
Objection, speculation.
Response? Your Honor, this is not speculation, as I have already laid adequate foundation to establish Mr. Perkins's personal knowledge of Alex and Blair. Therefore, under Rule 602, he has personal knowledge.
I'll
Response, Your
overrule
Honor.
the objection. Proceed.
Sorry, I couldn't hear you, Your Honor. Did you overrule the objection?
Overrule the objection.
Thank you, Your Honor. I will repeat the question. Based on your observations and from what you personally know, did Alex and Blair have anything in common?
Well, yeah, like I was saying, from what I know, they both had reasons to hate Mr. Brackman.
And based only from what you know, why did Alex hate Mackenzie Brackman?
Well, from what I knew, Alex always felt that Mr. Brackman was overlooking her talents.
To your observations, do you know why Blair hated Coach Brackman?
Well, from what I know, Blair hated Coach Brackman because Coach Brackman lost the case that got Blair's dad sent to jail.
Objection, Your Honor. Speculation, and may I be heard. I do not object so much to the substance of a reason why Taylor Perkins may believe and opine to why these two witnesses may hate Brackman, but the fact of the matter of whether or not they do hate Brackman goes to mental state and is therefore speculation.
Defense?
Your Honor, this simply is not speculation, as I was solely asking Mr. Perkins to testify to his personal knowledge. Therefore, he was not speculating, as he has personal knowledge under Rule 602.
Response, Your Honor.
I'll sustain the objection because it is speculation. Proceed, defense.
Yes, Your Honor. So, Mr. Perkins, based on your close relationship with Avery and from your observations of being on the mock trial team, do you think Avery Becker had a motive to harm Mackenzie Brackman?
No, I don't think Avery ever would have harmed Mackenzie Brackman.
Thank you, Your Honor. I have no further questions, and I pass this witness for cross-examination.
Proceed, prosecution, with the cross-examination.
Mr. Perkins, you saw Avery and Coach Brackman fight.
Well, yeah, I mean, like, define fight. I never saw them exchange blows or anything like that. But, I mean, yeah, they would definitely get into it a little bit.
They would shout at each other.
Yeah, I mean, they would definitely argue.
Avery would get frustrated.
Well, yeah, I mean, I think it's kind of natural to get frustrated when you're, you're doing so well in a sport or mock trial, and your coach just for some reason it was just refusing to acknowledge that. I mean, I think that could get to a lot of people.
Avery got so frustrated on one occasion that Coach Brackman demoted
Objection,
Avery.
speculation.
Don't finish the question.
Yes, Your Honor. Brackman demoted Avery to the B team after they fought.
Are we doing the objection?
Is there still an objection? Defense?
Yes, Your Honor.
And repeat the objection.
I object speculation, as Mr. Perkins cannot accurately testify to the mental state of Miss Becker.
May I briefly respond, Your Honor?
Go ahead.
Your Honor, as you have previously ruled pursuant to Rule 602, it is within the witness's rationally based perception to observe his friend's interactions with Mackenzie Brackman and opine to his friend's feelings based on what he can rationally perceive. It is also the substance of the question is the demotion of Avery Becker to B team, which is substantive evidence.
So restate your question.
Mr. Perkins, Avery and Brackman fought so much that Brackman demoted Avery to B team.
Well, yeah, I mean, that was just unfair.
Let me rule. I'm going to overrule the objection. He can testify.
Well, yeah, I mean, that was just unfair. I mean, Avery was clearly the best on the team, and she clearly deserved to be on A team.
You stepped down from your spot on A team to let Avery have her spot back.
Well, yeah, I mean, like, to be completely honest, I really wouldn't have even done mock trial if it wasn't for Avery in the first place. So it really wasn't that big of a deal for me to step down and give my spot to her.
You stepped down because she's your friend.
Well, yeah.
Now, let's talk a little bit about how you've got involved in this case. You were contacted by Avery Becker's lawyers, correct?
Well, yeah, I mean, I think it makes sense since I know for a fact Avery didn't do it because she was with me all day.
Sorry, that's a yes.
Yes, I was contacted by her lawyers.
And promptly after you were contacted, you called Avery Becker.
Yes, I believe that's true.
You had a conversation with Avery Becker about Alex Fuentes.
Yes.
In that conversation, Avery Becker told you that Alex Fuentes had fake text messages.
Yeah, I believe that's what Avery told me. I mean, I definitely wouldn't put it past Alex. Alex always kind of had a chip on her shoulder against Avery.
Avery told you that Alex might have taken her phone.
Yeah, well, I mean, again, that kind of makes sense. Like the last time I saw Avery's phone was with Alex at the Fry Shack, and then it was lost that next morning.
Avery told you that Blair Rollins could be a suspect.
Well, yeah, I mean, like, I don't think she necessarily really had to tell me. I mean, like, it's kind of notorious at our school that Blair's a little weird and has a reason to not like Coach Brackman. But yeah, I mean, she did tell me that.
Now, you wrote a statement for this case, correct?
Yeah.
And in that statement, you said, never in a million years would you have suspected that Blair Rollins would have done this.
Well, yeah, I mean, like, it's hard to expect anyone to have the capacity to do something like this, you know? Like, it's shocking when it's someone you hear about something like this on the news and it's a bunch of people you don't know. So let alone someone I know personally.
You never would have suspected Blair unless Avery told you.
Well, yeah, I mean, I guess you could say Avery was the one that got the gears kind of turning, but I think it kind of makes sense.
Thank you very much, Mr. Perkins. Let's talk about the evening of March 5th. You and Avery were spending time together that afternoon.
Well, yeah, I mean, we were best friends. Of course, we're going to hang out a lot. So, yeah.
Avery had tried to go to practice earlier.
Well, yeah, I mean, Avery was still trying to find a way to get on the mock trial team. So, yeah.
But Avery was kicked out of the practice.
Yeah, I mean, like, I don't know. I think it's just a sad situation in general to see someone that good at a sport get kicked off for reasons that I would argue were unfair.
You went to the Fry Shack with Avery?
Yeah.
And Avery got upset, in your own words, because she saw the team.
Well, yeah, it was more specifically that she had to sit down and talk to Alex. I think that's what really got to her. But yeah, she did get upset that night.
She stormed off to the bathroom.
Yeah, and she even left her phone behind, which was like so weird. I mean, normally she would have that thing everywhere. So for her to leave it behind, she must have been pretty upset.
In your own words, she was really upset on the night of March 5th.
Well, yeah, I mean, like I was saying, seeing everyone there must have made her really sad.
That's a yes?
Yeah.
Let's talk about the morning of March 6th. You met Avery that morning.
Well, yeah, I mean, she takes me to school a lot. So, yeah, she was picking me up, taking me to school.
You discovered together that Avery's phone was missing.
Well, yeah, I mean, normally she would text me when she's picking me up, but that morning she hadn't, which I thought was a little weird. And when I brought it up to her, she realized she didn't have her phone.
Mr. Perkins, for the purposes of expediency, I would ask that you respond as a yes or a no. You discovered together that Avery Becker did not have her cell phone that morning.
I'm sorry. I'm just trying to add the context I feel is necessary to the question. But yes, we did discover that morning she didn't have her phone.
You went to go and look for the cell phone.
Yeah, we ended up retracing our steps the whole day.
You went to the mall?
Yeah, we went to the mall. We went to all in the stores that we had been in before. And then we also checked the Fry Shack too, but we couldn't find it anywhere.
You don't mention in your statement any stores that you visited.
Well, no, but like we were in the mall, so we were just perusing around and stuff.
Thank you very much, Mr. Perkins. Let's talk about what you did after the mall. Now you leave the mall and you go to the Fry Shack, correct?
Yeah.
You encounter the mock trial team at the Fry Shack.
Yeah. It's weird to think that they were only there because something so terrible had happened to Brackman. It's almost surreal when I look back on it.
Yes, in your own statement, you reflect, it's strange to think that at the same time, Brackman was bleeding out on his porch.
Well, yeah, I mean, it's crazy. It's just like, I guess it just goes to show that terrible things can be happening in the world and we're all just ignorant to
Perkins,
it.
that was not my question. In your statement, you said it's strange to think that Brackman was lying out on his porch.
Well, yeah, I mean, like I was saying, it was strange. It was almost
And you've
surreal.
never been to Mr. Brackman's house?
Well, no, but I had heard what had happened.
Thank you, Mr. Perkins. I have no further questions for the witness at this time.
Ms. Donde, do you have a redirect?
Yes, Your Honor. Mr. Perkins, why did you leave the mock trial team?
Well, just because I just never really cared about mock trial that much to begin with, and I think Avery deserved the spot way more than I did.
Thank you, Your Honor. I have no further questions.
Okay, the witness may be excused. Defense, do you have a third witness?
Yes, Your Honor. We call Avery Becker to the stand.
Proceed.
Good evening. Can you please introduce yourself for the jury?
Yes, my name is Avery Becker.
Why are you testifying here today?
I am here testifying because I would like to prove that I did not commit the crime I'm being accused of.
To start off, I'm going to ask you some personal questions. Were you on the mock trial team at Colorado High School?
Yes, I was. I love mock trial. I was a part of it for all 4 years of high school, and everything about it I just love.
What do you like so much about it?
Well, one of my favorite parts is getting to spend time with people that say I didn't have a lot of classes with in school. It was a great time for me and those people to catch up. I also loved the mock trial competitions because being a lawyer came pretty naturally to me, and I honestly think that's why I was so drawn to mock trial in the first place.
Who are some of your friends on the team?
Well, obviously my best friend is Taylor Perkins. We spent so much time together, Tay and I. He and I didn't have a lot of classes together either, so mock trial was the perfect time for the two of us to catch up. We liked texting from across the room and hanging out.
Is there anybody who you didn't get along with on the team?
Well, I would say that I'm fond of most people on my team, but there was always something off between Alex Fuentes and me. It wasn't that Alex and I didn't get along, rather it just seemed that Alex was almost jealous of my natural mock trial abilities.
Could you please further explain more about why you observed Alex seem jealous?
So, as I said, I did have quite an aptitude for mock trial when I was on the team. I could easily examine anyone without really preparing, and I think that really bothered Alex. I also did miss practice a few times, and Alex never missed practice. He was always prepared. So I think it bothered him that he worked so hard, and I missed practice, but was still at the top.
Now turning to Coach Brackman, did you ever have any differences with him?
Well, with every relationship, there are ups and there's downs. Coach Brackman thought I needed to work harder, and he honestly knew that I had an instinct for mock trial. But
objection, speculation, and lack of foundation.
Your Honor, this is not speculation, as I have laid adequate foundation that Avery Becker was on the mock trial team with Coach Brackman, and so she herself can attest to the relationship that she had with Mr. Brackman.
I'm going to sustain the objection. It is speculation. Proceed, Ms. Davies.
We'll move on. Were you involved in an incident with Coach Brackman's car?
Yes, I was.
Okay, please explain this incident to the jury.
So before regionals, Coach Brackman bumped me down to B team for a while because he claimed I was never prepared, but he eventually moved me back up. And at regionals, I won Best Attorney Award and even Best Closer Award. After the tournament, Coach said that I didn't deserve the award and that I was going to make the team look bad at state. He said I was just relying on my good looks and that I was lucky.
Objection, hearsay.
Your Honor, this is not hearsay, as it is not being used to prove the truth of the matter asserted. This statement is not used for the fact that Ms. Becker's good looks gave her an advantage. She had good looks, but rather to show Coach Brackman didn't think she deserved the awards.
Prosecution, response?
Your Honor, the defense is using this as an example of Ms. Becker's interactions with Mr. Brackman. Therefore, Mr. Brackman's direct criticisms of Ms. Becker are being used for the truth of the matter asserted because they are being used to show that Mr. Brackman did have some sort of feud or rivalry with Ms. Becker.
I'm going to overrule the objection and defense, you may proceed.
Thank you. And what happened next?
I was really angry. I stormed out of mock trial practice, and we had been doing something on the whiteboard, so I had a whiteboard marker in my hand, but I later learned it was a permanent marker. I took this marker and I drew on Coach Brackman's Porsche. I thought it was a dry erase marker. I would never intentionally draw on Coach Brackman's car, no matter how mad I was. I thought it would wash right off. But understandably, after that, Coach Brackman kicked me off the team.
Did you ever try to apologize to him?
Yes. The next day, I went to his office, but his secretary said he was busy and didn't want to talk to me. So I sent him a text message and told him how sorry I was. I said I would try and clean the car myself or get a summer job in order to pay to get the car repainted, anything to fix my horrible mistake. But Coach Brackman never responded, so I never got the chance to apologize to him before he was killed.
Let's move to the day that Coach Brackman was killed. Do you remember where you were that day?
Yes, I do. I remember that day clearly because the day before was March 5th, and I was with my best friend Taylor at the Fry Shack. And we also went to the mall, but I had lost my phone. So on March 6th, I went to Taylor's house, and we decided to skip school to try and find my phone. So we retraced our steps at the Fry Shack and at the mall and kept using Taylor's phone to call mine, but it never picked up, so I figured it was dead or stolen.
Is there any time during that day that you were not with Taylor?
No. Like I said, Taylor and I spent the whole day together retracing our steps from the day before to try and find my phone, which was missing.
Do you have any idea where your phone was?
Well, I know for a fact that I had it at the Fry Shack because Taylor and I were playing video games on our phones, and a bunch of mockers from my school were there, including Alex Fuentes. I think Alex took my phone.
Do you have any information that supports this belief?
So it's my understanding that Alex claims to have received a series of text messages from me stating that I wanted Alex's help to get back on the mock trial team. And apparently I texted him and told him that I was going to go to Coach Brackman's house to trash it. But first, I would never do that. And I would never text Alex for help with anything. And I don't even know where Coach Brackman lives.
Moving on, can you please take a look at what has been previously admitted as Exhibit 14?
Yes, I can.
Remind us, what does the time say on these text messages?
It actually doesn't look like there's a time attached to these text messages.
Did you send these text messages?
Absolutely not. Like I stated earlier, my phone was missing, so I could have never texted Alex without it, and I never would have texted Alex, even if I had my phone.
Moving on, do you know who Blair Rollins is?
Yes, I do. Blair is another student at Colorado High School. I didn't know Blair very well, but I did know that Blair and Alex were close friends. I never talked to Blair a lot, but I do know that Blair did not like Coach Brackman because Coach Brackman lost Blair's father's case, which ultimately—
lack of foundation and speculation.
Defense, response?
In response to the foundation, Your Honor, Ms. Becker is testifying to her personal knowledge. And in addition, in the stipulated facts, it says that Exhibit 22 is an accurate copy of a recording from a portion of the video proceedings in this case against Jonathan Rollins.
Response, Your Honor?
Yes, please.
Opposing counsel has laid no foundation assuming that Ms. Becker was close to Blair Rollins. Therefore, the opposing counsel has also laid no foundation to assume why Ms. Becker might know this intimate information about Blair Rollins' father. In addition, Opposing counsel has not laid foundation to assume whether or not Avery Becker has listened to the contents of Exhibit 22. Therefore, just because it is authentic does not mean that it is within the scope of this witness's expertise or knowledge to testify about Blair Rowlands' father's case.
Response? No. I'm going to sustain the objection. It lacks foundation and it is speculative. Proceed with questioning, counsel.
Avery, after going to high school with Blair Rowlands, can you describe Blair's physical appearance?
Yes, Blair and I actually have a similar build and an overall similar height as well.
Moving on to Exhibit 13, Avery, can you please look at these exhibits and remind the jury what they are?
Yes, I can. So this is a video of the intruder walking up to what I assume is Coach Brackman's front door or maybe the back door. I honestly wouldn't know because I've never been to Coach Brackman's house.
Can you recognize any of the intruder's appearances from this video and relate them to yourself?
Well, from the short clip, I do notice that the intruder's height is similar to mine, but that just as well means that the person's height is similar to Blair's, and you can't even tell who it is as they're wearing long sleeves as well as a mask.
Finally, Ms. Becker, did you kill Coach Brackman?
Absolutely not. The only thing I did to Coach Brackman was damage his car, and I should not have done that. I did not kill Coach Brackman, and I just can't even believe that I'm being accused of it.
Thank you. No further questions, Ms. Becker.
Ms. Yufa, you may proceed with cross.
First, the prosecution asks for a quick time check.
Well, the prosecution currently stands at 4 minutes exactly for cross.
Thank you, Your Honor. Thank you, timer. Now, Ms. Becker, I ask for the purposes of the time constraints that you restrict your responses to a yes or no response. You are close with Taylor Perkins, correct?
Taylor's my best friend too.
You two were together all the time.
Yeah.
Now, I want to talk about the day that Mr. Brackman was murdered. You skipped school on March 6th.
I had lost my phone the day before, so I skipped school trying to find my phone.
I apologize. You say that you were at the mall on March 6th?
Yes, looking for my phone.
And the mall is a public place, correct?
Yes.
You claim that you walked all over the mall.
Trying to find my phone. We are retracing our steps, going in the stores that we went to, just trying to find it.
Only Taylor Perkins can verify that you were at the mall, correct?
I'm sorry, I think you cut out. I couldn't really hear the question.
Only Taylor Perkins can verify that you were at the mall, correct?
Everyone else was at school, so Taylor and I were the only ones there.
Not one mall employee recognized you.
I mean, I don't normally know the mall employees.
You didn't wave to anyone while you were at the mall.
As I said, it was a school day and a work day, so I didn't really see anyone that I knew.
You don't have a parent in court to confirm where you were.
A parent?
You do not have a parent in court to confirm where you were on March 6th, correct?
No, I don't, but Taylor is here and he can tell you that we were indeed at the mall looking for my phone on March 6th.
Again, I would like you to restrict your responses to a yes or no response. Now let's discuss all the details of your day at the mall that you neglected to provide. In your written statement, you don't mention the stores that you visited.
No.
But you said on direct that you remembered March 6th very clearly, correct?
Yes.
You don't provide any receipts to prove that you might have purchased something?
Well, as I said, we were there looking for my phone. We weren't there buying things.
You were there all day, correct?
Yes.
You don't provide any receipts from a lunch that you might have had.
Our sole purpose of going to the mall wasn't to hang out. It was to find my phone. So there were no recreational activities going on.
But you don't say in your statement when you left the mall.
Well, we also went to the Fry Shack that day, and I honestly don't remember the exact times, but
you don't say when you got home after the Fry Shack on March 6th, do you?
No.
Now let's talk about your feelings about Mr. Brackman. You were never very close to Mr. Brackman, were you?
Mr. Brackman and I often got in arguments, but I honestly looked up to him as a person. He got our team to a great place.
I apologize, Ms. Becker. Please keep your responses to a yes or no response. You did not think that he was a very good coach, did you?
I thought that in order for our team to win, I sometimes had to ad-lib from the scripts.
True or false? You say in your statement that
to me.
Ms. Becker, is that a yes?
Can you repeat the question?
Mr. Brackman told you that you just rely on your good looks.
Yes.
You wrote on his car.
Yes, I did, and I regret
Objection, improper character evidence under 608A.
Response, Your Honor.
Yes.
Your Honor, pursuant to, yes. Your Honor, pursuant to Rule 404B, character evidence in order to provide or a prior bad act for the purposes of motive, intent, and identity are all permissible. It is the people's position today that this is an identity crime. Identity is the main component of this case. And the question today being asked is who had the motive to go to Mr. Brackman's house to destroy his private property? A prior crime that Avery Becker committed with the intent to destroy Mr. Brackman's private property directly relates to the crime that we are talking about today. So this is an identity evidence and it is admissible pursuant to Rule 404B.
I'm sorry,
Oh, can I please have a response?
Yes.
Thank you. This has nothing to do with her truthfulness or untruthfulness, which is why it's under improper character evidence.
I'm going to overrule the objection. Sorry, Ms. Yufa, you may proceed.
After you did this, you went home, correct?
I don't remember what we were talking about. Sorry, could you remind me?
After you vandalized Mr. Brackman's car, you went home, correct?
Yes, I did.
And you told your mom that you would get back at Mr. Brackman if it was the last thing you do, correct?
This was my senior year on mock trial, and being kicked off the team devastated me. I wanted to be back on the.
Thank you. I have no further.
Your Honor, that is time.
Okay. Defense, do you have redirect?
Yes, but can I please have a quick time check?
On direct, you have 3:46.
Thank you. Miss Becker, did you vandalize Coach Brackman's car?
I did. It was one of the worst mistakes that I've ever made, and I regret it so deeply.
Was this act an accident?
No, it wasn't an accident, but it was an accident that it was a dry erase. It wasn't a dry erase marker. I thought it would wash right off.
Did you ever try to apologize to Mr. Brackman because of this incident?
Countless times. I did everything I could to try and fix the incident. It was a horrible mistake. I went to his office. I texted him. I just wanted to fix this, but I never got the chance to apologize before he was killed.
Thank you. No further questions.
Okay. Do you want to proceed, prosecution, do you want to proceed with your closing?
Yes, Your Honor.
Proceed.
It might be hard to understand that a teenager would do something like this, but the overwhelming evidence compels you to convict Avery Becker of the murder of Mr. Brackman. Now, I'd like to direct your attention to jury instruction number 7, the definition of murder in the first degree. Now, the prosecution and the defense agree on the place and time of the murder, the fact that the perpetrator broke into Mr. Brackman's house with the intent to, at a minimum, destroy, and the fact that Mr. Brackman was killed as a result. The only thing that the defense and the prosecution disagree on is identity. Who killed Mr. Brackman? Who had the means, the motive, and the opportunity to kill Mr. Brackman? The defendant did. Now, I'd like to start with means. The means for this crime were inside of the house, so whoever went into the house had the means to kill him. Motive. You heard Alex, Taylor, as well as Avery testify today exactly why the defendant did this. You saw the evidence showing Avery Becker's resentment when Mr. Brackman wouldn't continue to criticize her during practice, evolve into anger as the defendant ran outside to Mr. Brackman's car and destroyed it, and to fury as Avery runs home to tell her mom, "I'm going to get back at Mr. Brackman if it's the last thing I do." And then she sends a fundamentally identical text to Alex Fuentes, saying that she was going to go into Mr. Brackman's house and trash it. That'll show him. That'll show him for taking away something that meant everything to Avery. This was the edge. Mr. Brackman would never take this away from Avery again because Becker was going to teach him a lesson. It turned out to be a deadly one. Now, finally, opportunity. Today, you saw that the defendant was missing on March 6th. And you saw the CDR data tracking the defendant all the way to Mr. Brackman's house on March 6th. The defense claims that the defendant had an alibi for this case, but let's talk about that alibi witness. Taylor Perkins is Avery Becker's best friend. And yes, the prosecution agrees that Taylor was with Avery on the day of the crime. However, neither Avery or Taylor provided any evidence to show that they were at the mall. Now, you saw the ring video. You saw that it was impossible for a passing motorist to see Mr. Brackman's body on his porch. Avery fled and told Taylor exactly where the body was. The defense did not prove an alibi. Instead, they established an accomplice. The defense also brought Professor Van Owens. And Professor Van Owens threw up a couple of scattershot hypotheticals that did not refute the bottom line. The culmination of the facts point to one person. And crazy scattershot hypotheticals don't establish reasonable doubt. They don't change the fact that Avery Becker had the means, the motive, and the opportunity to commit this crime. So why did Avery commit this crime? Because when Mr. Brackman doesn't let Avery do what Avery wants, the defendant goes to get revenge. On March 6th, the defendant got revenge. But this time it went too far. The prosecution asks you to look at the evidence and convict Avery as guilty. Thank you.
Defense, you may proceed with your closing.
Thank you, Your Honor. The prosecution must prove beyond a reasonable doubt that Avery Becker murdered Mackenzie Brackman. The prosecution failed to meet this burden due to several key facts. First, Detective Markowitz conducted a rushed and sloppy investigation and considered no other suspects. Second, Avery was not at the crime scene and has a solid alibi, Taylor Perkins. Third, and most important, the evidence in this case points to two alternate suspects, Alex Fuentes and Blair Rollins. The prosecution tried to convince you that Avery killed Coach Brackman because she was demoted to B team. but Alex and Blair are the individuals who have motives. Alex desired to become a mock trial star, and Blair's desire to kill Coach Brackman to get revenge for sending Blair's father to jail. Let's investigate these points in a little more detail. First, the prosecution's key expert witness, Detective Markowitz, clearly rushed the investigation. Ms. Van Owen told you that Detective Markowitz jumped to conclusions with the knife and the cell phone tower data and never considered other suspects. In addition, Detective Markowitz ignored the fact that there is zero physical evidence that connects Avery Becker to the crime scene. No fingerprints, no DNA, nothing. You can't even see who the assailant is in the ring video. Second, Avery Becker was nowhere near Coach Brackman's house on the day of the murder. Taylor Perkins, Avery's best friend, testified that Avery lost her phone the day before the murder and that on the day of the murder, they were together the entire day looking for her phone. In addition, Mr. Perkins explained that he and Avery were nowhere near Coach Brackman's house. Avery herself confirmed this. And Avery confirmed that she did not send the text messages that Alex says he received from her, as she did not have her phone. Third, Alex Fuentes had a dream and a plan. As Avery testified, Alex was jealous of Avery and wanted to get her out of the way. Alex went to every practice and prepared for every trial. However, none of this dedication or work allowed Alex to outshine Avery in competition. This is because Avery is an accomplished student who has incredible mock trial abilities. Imagine how frustrated Alex must have felt working as hard as possible, but never being able to outshine Avery. Meanwhile, Blair had a reason to despise Coach Brackman. Coach Brackman lost the case that sent Blair's father to jail. With this, it is easy to see why Blair wanted revenge against Coach Brackman. Alex had a dream and a plan, and Alex used Blair's desire for revenge in order to accomplish it, as Alex wanted Avery to go to jail and Blair wanted revenge against Coach Brackman. This was the perfect crime, as it would ruin both the lives of Avery Becker and Mackenzie Brackman. The prosecution would like you to believe that Avery Becker's had the means, the motive, and the opportunity. But you've heard all the evidence here today, and there is no evidence that supports this. Instead, the evidence shows that Alex and Blair are the individuals who had the means, the motive, and the opportunity. Members of the jury, the prosecution did not meet its burden of proof. Not only did the prosecution shortchange its investigation, but Avery was not even at the crime scene. In fact, there is no physical evidence that connects Avery Becker to the crime scene. And most importantly, there are other suspects, Alex Fuentes and Blair Rollins. Not only does Blair have a general build as Avery, but these two individuals both have clear motives to murder Mackenzie Brackman. I ask you to find the defendant not guilty.
Prosecution, do you have a rebuttal?
Yes, Your Honor. Permission to proceed?
Yes, go ahead.
The defense claims that Alex Fuentes had a dream and a plan, but they didn't talk about anything with Alex Fuentes about Blair Rollins and whether or not Alex even knew Blair Rollins. You saw today that Alex was confident in his place on the team and he saw himself as buddies with Avery Becker. The defense also claims that there was no physical evidence connecting Avery Becker to the crime, but you saw the text messages, you saw the CDR data tracking Avery to the scene of the crime. Thank you.
Thank you. That concludes this trial. I appreciate everyone's contribution, and that concludes it. Thank you.
Your Honor, at this time, I will invite panelists to make remarks, and you can also make remarks as well if you so choose.
Do we need to give panelists a little time?
Yes, let's give them a few minutes to complete their score sheets. We are remaining on the live stream. You may give remarks at this time if you would like to.
I appreciate everyone's time and effort in this. Both sides are amazing. I know you guys have risen up through the ranks to this level, and it shows. That's all I have right now. And if the panelists are done scoring, they can have their remarks.
Hey, everyone. So I want to say I think both teams did a really great job. I believe that I did have the pleasure of judging one of the teams beforehand. So it was, interesting to see how you guys had developed your cases since that time. I really liked what I saw with both teams making good objections and thinking quickly on their feet. And there was a lot of really good digging into the rules and some really good arguments and counter arguments. And I really like to see that.
I think everybody did really good. I was impressed on a number of the things. One of the things I think you guys know really well are how to lay your foundations. And that came across really strong and clear. To all the witnesses, you know your role, you know your people. It was interesting. I thought you did good to be able to answer some of the, questions that probably felt a little out of left field, excuse me. One thing I would say is you started with having a little bit of kind of your themes at the beginning in your openings. That should, because this is a team, you should have that through the whole case. So we had a trilogy in your openings. You had kind of where you were going. Don't overemphasize it in your opening because you want to nail that home, but you want to sell it at the beginning and then continue. Even if you're not using those exact words on your cross-examinations or your directs, remember that that's kind of what you're establishing. The other thing I noticed, some of you did really, really well, and then some also struggle with it. Sometimes it's okay to say, after they say objection, I'll rephrase, fine. We're not even worried about that. I know one of you did that actually without saying I will rephrase. You just rephrased the question. It was perfect. It wasn't objectionable, but because the court was still trying to rule on it, it didn't flow as well. There were other times where it had to do with the foundation for an expert. Some of you will just, nope, no objection. Sometimes knowing when not to fight something is as hard, or letting it go, as much as making the objection. And yeah, I really saw the strength in some of those as well. But overall, you guys really good. It was fun to watch and interesting to see what you all had done.
Well, I guess last but not least, first of all, I am a hearing officer with the Department of Revenue, so I hold hundreds of hearings a year and see hundreds of attorneys a year. And I would welcome any one of you into my courtroom at any time. And hopefully at some point in the future, maybe I'll see you there. I think that all of you have the ability and the skills to become lawyers if that's what you choose to do. So I really do want to congratulate everybody on making the state tournament. that's a huge achievement. So when I offer some of the comments, just be aware of the fact that overall both teams did an absolutely outstanding job. So these are just little things here and there to maybe improve in other rounds or in the future. First of all, I judge mock trial several times. I've done it for like 15 years, and some of these things I say every single time, and one of them is slowing down a little bit. Not everybody, but a lot of the people, you tend to speak too fast or don't realize how fast you're speaking. And if you just slow down a little bit, even if you think you're speaking too slow, it really is helpful. The other thing is especially on cross-examination, of starting each sentence with an "and." You ask your question, and then you ask your next question, and then you always using "and" before questions, and that kind of gets a little distracting. The other thing I would say is the other thing that gets a little distracting is when you thank witnesses. So the witness will answer a question and they'll say "thank you," and then you'll ask your next question. That can be distracting. And finally, I would agree with Ms. Garson that sometimes I think, you both teams did a very, very good job with objections, and both teams did a very good job in answering objections, and both teams absolutely had thorough knowledge of the rules of evidence. But sometimes you get a little bit of lost when it's going back and forth, and it takes away from the case. So I would ask you to consider, is an objection really necessary, or is it just going to be a distraction, or even worse, sometimes emphasizing the other side's point? So I would just consider before making objections, thinking if it's really necessary or if it's just going to distract from the case. But overall, everyone did an outstanding job. You clearly knew your case, you clearly knew the rules of evidence, and you clearly deserve to be here at state championships, and I congratulate you all.